believe Mr. Klein's pled Javaris Derm in one trafficking case, where he may not have been charged, but with trafficking.
I can't recall other than I remember there were several Derms. I don't think.
Mr. Derm pled to possession of controlled substance and baby paraphernalia. Might have been time served. He'd been in jail since like September. I looked at the plea agreement. It was time served May 29th.
Okay. Yep. I've got a miscellaneous day on September 25th.
That is fine, Your Honor.
I mean, I'd rather go later than in September since you don't actually have the dates yet.
September 25th is fine, Judge.
All right. I'm still going to set it for the October pretrial,
Understood.
just so it has a pretrial date still. So September 25th, basically for status after the depositions. October 29th for purposes of the next pre-trial conference. But Mr. Derm, if y'all get it done, worked out, you can always find an earlier date to come in and get it resolved, especially if it's something like
Absolutely,
time
yes.
served. All right. Anything else for Mr. Derm?
No, Your Honor.
All right, thank you, Mr. Derm.
Have a good day.
Is that all you have, Mr. Derm? Yeah. All right, Mr. Riasti. All right, do you want to handle Douglas now and then?
Your Honor, Mr. Douglas is present. Christian Alexander Douglas in 2023 CF 111C. I'm working with the state to try to have this case ready to try this cycle. So I'd like to leave it set for docket day
As what, as trial?
for trial.
I guess, yeah, plea or trial.
Y'all have figured out all of the cell phone issues and Orlando experts and search warrants and all that?
Yes, Your Honor.
Okay. So what ultimately happened with the cell phones?
The state downloaded the cell phone data and is providing it to me and
From Mr. Douglas's phones?
from Mr. Douglas's phones.
Okay. So did y'all ultimately get a warrant on that, or was there a consent to that?
It was a warrant, a search warrant that was signed.
They haven't been downloaded or turned over yet?
They have been downloaded, Your Honor, and this morning I personally went to the headquarters in Shalimar to pick up the thumb drive, which is here. And then Mr. Riasti gave me this hard drive.
Okay.
So now the next step is for me to copy the two downloads from here to this. And I said that I'm gonna try either by tomorrow, if we cannot do it at this office in Crestview because of the capabilities of our computer, I would have to take them to Fort Walton Beach office where we have an IT person, and then it can be done, I'll say by Thursday. That's the best I can do.
Well, I understand. It's just, we're setting a case for a trial where you haven't seen evidence that you've been talking about for 6 months, Mr. Riasti. And if y'all are going to be ready to go, that's fine. I just don't want this to be a situation where we set it for trial and continue it again. But I'll put y'all down for trial, but we need to be ready to go. The benefit of this particular cycle is there's an extra week in there, right? So
Yes.
we've got docket day next week, but jury review's not until the following week, which is, what, July 11th? So we've got an extra week in there than we normally do. So we should have time. I just want to make sure it's getting going.
Yes, Your Honor.
Mr. Douglas has been incarcerated for 2.5 years and hasn't.
The resolve it, Your Honor.
I think you know I've been trying to push this to a resolution one way or the other ever since I took over, and then these cell phone things have really caused a problem with that. Are there any other pending motions or anything?
Not from the state.
Okay, I just want to make sure. I mean, we can get them set, we can get them heard, but we can't do it 2 days before trial is what I'm concerned about. So if there's going to be any motions in limine or anything else that comes out of what you find, Mr. Riosti, file it quickly,
Yes, Your Honor.
and we'll get a hearing set.
Yes,
As you know, I do not like doing evidentiary hearings or things that could be dispositive of the case while members of a potential jury are sitting in the next room waiting on us.
Yes, yes, Your Honor. I said, my goal is now to give Mr. Riosti the copy of the phone downloads.
Yeah, to talk to you about the motion.
All right, so, Mr. Douglas, we'll see you back on Monday. That's going to be June 30th.
I'll be here to talk to you.
All right, we'll see you all on Monday, June
Thank you.
30th. That's next Monday, Mr. Douglas. Obviously, if there's anything that comes up between that now and then, I'd like to know so we can keep this thing pushing forward. All right, thank you, Mr. Douglas.
The other inmates are not available? All right, thanks.
All right, so I've got Mr. Stewart next.
Good morning, Your Honor.
Morning.
May it please the court, Your Honor, Brad Stewart on behalf of Donald Jesperson, Judge. Several cases before the court, Judge. I do need to ask to continue this. We've had 2 prior attempts to depose one of the law enforcement officers on the trafficking case. They have not shown up, Judge. I am in contact with that law enforcement officer and anticipate that we'll be able to resolve this and move forward on our next cycle. I do believe that we have the other cases resolved ultimately in principle as long as we can move forward with the trafficking case.
So are you doing a third deposition attempt?
That's correct, Judge.
Leonie, is there a reason why the officer's not showing up?
No, no.
Has he
not
been
that I know.
served?
I don't, it was served, I believe. Are you referring to
Yeah.
Jenny?
Yeah.
I don't know, Your Honor, why he didn't show up. You said you've been in contact with them, Mr. Stewart? Okay, he's been in contact.
I just, again, people aren't showing up. There's avenues about making them do that and not just hoping because you talk to them that they're going to show up. Because it sounds like y'all potentially have a resolution if you can just get a deposition done. So Mr. Jesperson's been waiting around for that for a while. So August 27th, is that what you're looking for, Mr. Stewart?
Yes, Your Honor.
All right. Obviously, if y'all get something worked out, put it on an earlier docket if it resolves it.
Yes, Your Honor.
But,
That's all I have. May I be excused?
yes, sir.
Thank you.
Some of these cases are from 23. All right, Ms. Dudley.
Your Honor, this is Matthew Bachman in 21 CF 2261 and 23 CF 2528. Your Honor, we have a deposition set on August 11th and August 13th. I would ask for a continuance to the next pretrial.
No objection, Your Honor.
You have 2 days for the depositions already?
Yes, sir.
From November of 23. So I would expect we'd be ready to resolve it next time around,
Yes, sir.
August 27th.
Your Honor, this is Justin Diaz in 21 CF 2951, 24 CF 1499. I do have depot set on August 20th. I did
Which
receive, on the 1499 case, I did receive the transcripts of the depots in the 2950, the 2021 case. The case officer looks like was never served, that he was no longer with the law enforcement agency. I don't have an updated address for him. I did contact prior counsel. They said they never got him served for those depositions that they set. And reach out to the state, see if I can get some kind of address for him and add him to the 8/20 date, if I can, so I can get both these cases taken care of. So I would ask for a continuance to the 8/27 date.
Ms. Leone, you're case?
Yes, it is.
Do you have a way to contact this former officer?
We can.
Because it sounded like you were looking for the address. I just want to make
No,
sure.
that's how I was gonna get with the state, Your Honor.
Okay.
I just found out from the prior counsel, I got the transcripts, and there wasn't one for him.
Thank you, man.
All right, we'll see you back on August 27th, Mr. Diaz.
Your Honor, this is Robert Jones and 24 CF 2083 and 24 CF 2735. I would ask for a continuance. I just got discovery on Friday. I need a chance to download the digital evidence and go through all of that.
August 27th, 9 o'clock.
Thank you, Your Honor. Yeah, this is Gil McGinn, 24 CF 376, 24 CF 669. Yeah, I would ask for one last continuance. There's a witness that I've talked to on the phone, but I need to get in for a deposition. We tried to serve her twice. I need to try one more time to get her served. The information that I've been given, I believe helps my client. I think this is going to be a trial based on the state's offer in this case. So I'm asking for one more chance to try to get her served for deposition or get her into the office.
So you've been attempting to serve her, but can't serve her.
Yeah, we can't get to the house. So I'm trying to get her, if I can get her to meet my process
Can't
server
get
somewhere.
to the house?
I think there's a dog, so we can't, the process server can't get to the door to get the subpoena.
All right, and this is a lay witness. It's
Yes, sir. Yes, sir.
not law enforcement. Okay.
No, sir, it's not. We did all law enforcement, I believe.
So Leonie, have you had any contact with this particular
No,
witness?
Your Honor, as a matter of fact, the state does not need this witness to go forward. It may benefit the defendant to some extent, but obviously it's not cooperating to come into the deposition set by the defendant. So the state is ready for trial.
Based on the severity of the allegations, the state's offering 10 years at this point for her offer. I do need one more chance to try to get her in. I think we just did our last round of depots a couple weeks ago.
Yeah, June 4th. All right. 8/27, last continuance.
Would the record reflect that it's over state's objection?
Overstates objection.
Thank you, Your Honor. Now, this is Amon Robinson in 23 CF 812, 24 CF 638, and 24 CF 1682. I had a motion to unseal the search warrant,
For
Schedule.
July 31st.
but the state has informed me that they have no objections, so I will get an order to the court
Get an order to me.
to
Yes.
get that done.
Send it directly to my office.
Yes, sir, I will. Yes, sir, I will. We can get
As
to
we
one
talked
more-
about yesterday, just between the portal and the clerk's office processing, we just got to make sure. And what I'm trying to do on things that I consider to be time sensitive is just email y'all back a copy of the signed order and say, e-service isn't a problem, I don't think, at this point, so you should get e-served with it, but I don't want to take any chances because I don't want it to
Yes, sir.
slow you down on my end.
Yes, sir. If we can put it on 8/27, if I can get it resolved, I'll move it back up. I'm hoping that once I get that, if I need a motion, I can get it filed, and we can try to get these resolved. And I've spoken to Mr. Robinson about that.
All right, y'all had depots a couple weeks ago.
Yes, sir, we did.
Obviously, the 23 case is very old, so I'd like to get these resolved next time
Yes, sir.
around. 27 at 9 o'clock.
Yes, sir. Your Honor, this is Trace Marshall in 23 CF in 1981 and 19 CF 1607. I was recently hired to represent Mr. Marshall. I would ask for a continuance to the 8/27. Court date.
It's from August of '23. Why are we rescheduling depositions? Well, I understand that, but
You had.
I allowed for second depositions,
called
and
two of the witnesses.
Mr. Cobb is sitting here, he's the one that asked for it, and I
Yes.
allowed for that to happen, and now there's,
Well, I will get it done before the next court date, Your Honor.
August 27th, last continuance. No reason why a case like this should take 2 years.
Is that all you have right now? Okay. Okay.
All right. They'll tell me when the rest are up. All right, Mr. Cobb.
Judge, this is Victor Robinson, Jason Cobb on behalf of Mr. Robinson in 2025 CF 755. Judge, it's a battery on a jail detainee case from Crestview, but he has a new substantive charge that's scheduled before Judge Stone. It's 2025 CF 594. What we had done the last time this happened with Mr. Robinson is we transferred the felony battery down to Judge Stone's division so that we could try to come up with a global plea.
That's typically how it's done, and it goes to the earlier case number, which it sounds like Judge Stone's.
It is Judge Stone. And the Public Defender's Office represents Mr. Robinson in the case with Judge Stone. I have this case with him. So do I need to file a motion to transfer it, or is it something we can just agree upon?
The state will do that. I wasn't tracking it. It's my bad. And I'll,
I
make
don't,
sure that-
do you know what case that is that he's got in front of Judge Stone?
I wrote down 2025
At 500 something, I think.
CF 594. I might have written it down wrong this morning, but it's scheduled for pretrial on 7/14/25.
All right, yeah. When I clicked on his name, it didn't come up.
It's in one here.
In that case, he seems to have a different middle name.
All right, he's saying he only has one case. I'll look and see. I do know that there was some violations that took place, but those were resolved. And I'll just go back and look. So you're saying you don't have a case? Okay, I might have just saw a different Victor Robinson.
Yeah, he's Victor Tyrell Robinson, and the one I'm looking at on Judge Stone's docket is Victor Ricardo Robinson.
Okay. Good, and it's just my case then. So I guess it doesn't need to be transferred. That'd be great. I'd ask that we leave it on the June 30th docket day so I can get up with the state to try to work out a resolution. He's got a considerable amount of time in, and I want to talk to the state about a way to resolve it without having to ask for continuance right off the bat.
All right, August 27th, 9 o'clock. That's the first time up.
Oh, I was asking for June 30th,
Oh,
Judge.
I'm sorry. You
I
want
don't want to try to continue. I want to try to resolve it on June 30th.
I apologize. I was reading something when you said it, and I shouldn't have been doing that. June 30th, 9 o'clock, see if y'all can get it resolved. All right, we'll see you next Monday, Mr. Robinson.
You can do my floors, dude. See you later.
I don't understand on his case is why he was in jail at the time of a battery on detainee. 'Cause I can't
VOP.
find a case that was open at that.
I think he got arrested on a VOP for something. I think that, I was looking for the same thing.
We'll figure it out.
Judge, this is State of Florida versus Kevin Russell.
Okay.
He has 3 cases, but I believe the main case is the 2023 CF 2611. The other 2 are VOP cases. We have depositions scheduled on August 28th, but there wasn't an earlier date to do depositions, July 3rd at 1:30. Originally, I wasn't available because of travel plans, but those travel plans have changed. I am available now for the July 3rd, 1:30 time. I mean, to do the suppression hearing. It's a suppression hearing, sorry, not depositions, my bad. And Ms. Leon was available then, but I don't know if you're still available the July 3rd, 1:30.
No, because we issued subpoenas for the new notice that you filed based
Right.
on, yeah.
Yeah, then August 28th is the date that was available. I didn't want to push it out that long, but scheduling was,
This is a motion that was filed back in May, right?
I
Oh,
had
Did y'all have the transcript that you were wanting to
I did
attach?
get the transcript, and I had originally filed an email to the court team requesting a hearing. I looked through my emails, and I didn't see that I'd gotten a response back. It's probably my fault. I'm not going to blame the court team because they're always really good about emailing me back. So I sent a second email, and then it got coordinated with Ms. Guzman, and the August 28th date is the date that we were all able to agree upon. And I understand the state had to send subpoenas out, and so that July 3rd date's not available anymore. I get that. But if the hearing is on 8/28, it's going to have a pretrial after that. But the state has made an offer of 65 months DOC. I went down to the jail and spoke to Mr. Russell about that. I've asked Ms. Leon to leave that offer open for an additional week so I can go down to the jail and talk to Mr. Russell again about it.
And I would like to speak with the judge.
Well, I would advise you not to speak to the judge, but if you
would
are
like
intent
to.
on doing it,
Yes,
that's
please.
your right, I guess.
Your Honor, my counsel, Jason Cobb, established that Officer Sprague of Crestview City Police Department made an illegal arrest, search, and seizure.
That's what the
20
suppression motion is, right, Mr. Cobb?
Yes, sir, that's-
Okay.
March the 28th, 2025, they deposed Miss Asia Sprague, Officer Asia Sprague, my counselor, Jason Cobb, along with Ariana Leona, and she admitted that she had no probable cause to arrest me.
I went to the jail last week and spoke to Mr. Russell, and he wanted the case to be dismissed today. I tried to explain to him that we got to have a suppression hearing on that case, and the date that we have to do it is August 28th, unfortunately.
But I'm been held when the arresting officer admitted she had no probable cause to arrest me, Your Honor. I've been here 17 months for the record.
One of the issues that causes a little bit of problem in his case is he's got the VOPs as well.
I have 35 months built up on that, sir.
And, you know, I talked to him about the state choosing to move forward on a VOP evidentiary hearing, and I discussed with him the burden of proof is different on a VOP. So the offer's been extended for a week, so I can go down to the jail and re-explain
here
these
illegally.
issues to
Hold
him.
on just a second. I'm looking through something.
And the suppression hearing is scheduled for August 28th.
I'm hoping we can get this cause and matter resolved today,
Mr.
sir.
Russell, if I could, I'm just trying to read something right now. I just want to be able to hear everything you have to say while not being distracted, but I think it's important that I read the transcript. Y'all are talking about it's only a couple of pages, so I'm just trying to breeze through that quickly. What's the issue with the arrest, Mr. Cobb?
Well, it's going to be a novel argument, Judge. They arrested him for domestic.
Make it shorter than a novel for today's
Arrested him
purposes.
for domestic violence battery. They admitted they didn't have probable cause to arrest him for that, but they did have probable cause to arrest him for battery. But
Yeah, I don't think there's really much of a difference.
it's an argument I'd like to make, so that's why I did this.
It might not have been domestic violence battery, but certainly they had a legal
what they
arrest
charged
for
them with.
battery, and the statute allows a warrantless arrest for those crimes. That's the state's argument.
Well, I think we're going to have a motion hearing on that. So are there no other earlier dates that you can get that on, Mr. Cobb? I know you talked about the July 3rd, and that doesn't work, but
Well, one of the issues I had is I have the Lonnie Strahan trial that's scheduled that the second trial week in July that I've asked the court to block off, and that's already been scheduled, the 14th, 15th, and 16th. And then the following week, I was going to be out of town. I can't do a suppression hearing via Zoom. And so the 28th was the date that came back that we could set them for.
Your Honor,
yes.
may I, since the only witness that the state would need is Deputy Sprague.
Officer Spring.
No, it's Deputy, Your Honor. She
Rescue.
worked for the.
Oh, did she
no.
move?
Yes, Your Honor.
Okay.
Yes. So I can try to reach out to her and see if she would be available on July 3rd at 1:30, and we can have it then.
Well, let's put it on for maybe June 30th, this coming Monday, and we'll find out if we can do it on the 3rd.
Yes, I will have known by then.
Okay.
Yes, sir. Thank you.
So that would be a second depose of Ms. Bragg.
It won't be a deposition, it's a hearing.
Okay, hearing.
That's the hearing that you're looking for, Mr.
Statements
Russell.
that I made today, Your Honor, are true. In fact, she did admit that she did not have problems.
I just scanned through the deposition.
Yes, sir.
I asked what your attorney said the argument was, but we'll have an actual hearing where the state will have to put on their evidence. Both sides will make argument. I'll make a decision as to whether or not probable cause existed.
Yes, okay.
But-
The reason why I asked, because I don't get explained, I don't get explained to me like it's supposed to be explained to me.
Well, I'll let Mr. Cobb try to explain it, but I think that's the gist of it is they're hopefully going to be able to get a hearing next week if the now deputy can make herself available on that particular date.
Yeah, and I'm going to come back down to the jail and explain it to you again, everything.
Okay. All right. Thank you, Mr. Russell. We'll see you on Monday to find out if everything's set up for the 3rd.
What case is this?
Cordell Thomas. I think you were just appointed to it.
Yeah, I didn't have that on my list.
You were, yes.
Yes, Your Honor.
You were appointed on June 3rd, Mr. Cobb.
Okay. What's the case number?
It's going to be 24 CF 906
9 what, Judge?
06. This is a quick catch-up, Mr. Cobb.
What's your name?
There's a pending motion to suppress. I think we ultimately had a Nelson hearing a couple weeks ago, and it was just a situation as to Mr. Thomas has had several different lawyers from Regional Office of Conflict Counsel that he was dissatisfied with. So, because they switched several times during our recent changeover. Mr. Maddox, do you have the other case still?
I do, Your Honor. It's Mr. Cordell Thomas, 24 CF 2845. I spoke with Mr. Thomas at the jail. I'm just asking a continuance. I'm going to get the deposition set, Judge.
When did you take that case over?
I'm not sure. His felony plea date was January 30th.
Okay.
I took it sometime after that, Your Honor.
What's the other case number that the PD has, Mr. Thompson?
24 CF 2845.
be asking for a continuance so I can get down to the jail and speak with Mr. Thomas, Judge. What would that date be?
The next pretrial is August 27th. All right. Any issues with that, Mr. Thomas? Obviously, Mr. Cobb just got on your case, and it
Yes, sir.
seems like he wasn't even aware that he got appointed. I'm not sure when the order came through.
I looked
It
at
was
the
on the
docket
29th,
yesterday.
it was the 29th of May. That's when, it was my last court date. I think
I thought it was
Mr.
June
Scott
3rd.
said he was gonna,
It was
email
June
him.
3rd. Here's the issue. Although I ordered it at the June 3rd hearing, I don't see an order that was sent over for me to sign to that effect. So,
I was caught a little bit unawares
yes,
this morning. So.
and that makes sense, that an order never went out to you, so you wouldn't know you were appointed at this point.
But I can get up with the RCC, or I can send over an order and I'll get it done.
Just make sure there's an order. I know you're going to need that at some point anyway.
Yes, sir.
You'll be able to come soon.
All right,
Yeah.
Mr. Thomas, you're going to be August 27th at 9 o'clock.
Yes, sir.
I will come out and see you about that case that he now is aware of.
And then you'll have to reset a hearing date for the.
I'm going to let Mr. Cobb do that once he's kind of caught up with the case, because I want to set it too early where he's not ready.
Yes, sir.
But we've got plenty of dates. We'll get them set as early as we can.
All right, thank
Your
you.
Honor, I was actually going to ask the same thing, if we can go ahead and set the hearing, because I'm afraid that then we reach the next date for Mr. Cobb then to want to set it. It's a very straightforward issue.
Okay.
The court might have had the chance already to have seen the videos in that case, so.
Okay, I do recall it now. I watched, y'all gave me the video to watch. It was about 20 minutes because this was set for a hearing before.
Yes, Your Honor, that's what I mean. And so,
But my concern is Mr. Cobb hasn't seen anything or even talked to Mr.
Thank you.
Tom.
Thank you.
If y'all want to come back on Monday, are you going to be here Monday already? I think you are, for Russell.
Oh, yes, I got a couple.
Why don't we
more.
keep this on for Monday so you can maybe take a quick look at it, Mr. Cobb, and see if you want to get a hearing date set.
Yes, sir.
Thank you, sir.
If I may, Your Honor, I'd still ask for the 27th.
Okay, we can keep yours on the 27th, so it'll just be the 906, 24 CF 906 case. That will be on June 30th for the status of setting that hearing.
It's simple. Thank you.
Thank you.
I'll get the discovery out today so I can just, the video.
yes, but I'm sure also Regional Conflict Counsel can share everything with you. They did the deposition, they got the transcript. That'll be faster, certainly.
That's a question I want to get on record.
I'll come
All
talk to you.
right, he'll talk to you, Mr. Thomas. All right, we'll see you back on Monday.
All right.
Judge Jason Cobb on behalf of Lonnie Strahan, 2021 1400. There's another case, it's 1404 or 1403. But the one that's scheduled for trial that we've had scheduled for July 14th, 15th, and 16th is the 1400 case. So that's still set. And so I'd like to leave it on docket, jury trial review, and then have those dates to do the trial if I can. Oh, got you.
Yeah, I'll be here the whole time, so. So, and I have that in my notes that we had talked about the July 14th date. So I've got it as jury selection plus 2 full days.
Yes,
So
sir.
14, does it have to be 15 and 16? Just so when I'm going through and figuring out scheduling for other trials that we know if it needs to be.
It'd be amenable for myself if it could be those days. But I think, we're leaving to go out to Utah on the 17th, but the plane doesn't leave until the afternoon. But that's why I was trying to get the 14th, 15th,
I
and
don't know if I
16th.
want to be in a situation where we're waiting on a jury and you're waiting on a plane, so. All right. I'll do everything I can to fit it into those dates.
I understand, sir.
Because you asked last time for them. I just don't, make sure I don't promise that to anybody else, so. All right, thank you. Anything else that we have to address regarding Mr. Strahan?
No, sir, I don't believe there's any.
Okay. We'll leave them for June 30th for purposes of docket day. Obviously, if any motions are going to be filed or need to be heard, they need to be heard before trial.
Yes, sir.
I mean, days before the trial, not 8:30 before the trial.
Yes, sir. It'd just be general motion limines, not very serious, but.
I still would like those to be done no later than the jury review the Friday before.
Yes, sir.
I mean, unless there's agreements on them, I just, it's enough that when we have jurors come in at 8:30 on Monday morning, we don't end up getting started till 10 o'clock or later just by going through the normal process. I just don't want to keep everybody waiting while we're doing those things.
Yes, sir.
And frankly, picking a jury when you don't know what the evidence might be is not exactly what I would consider a best practices. All right, anything else from Mr. Strahan? All right, we'll see you back on Monday. Yes, for now.
We're gonna go over everything. Yeah.
Hello?
Hey, Kiana.
Yes. Can't hear Ms. Basso, I guess. Okay. All right, thank you. All right, bye. All right. That side of the table needs to either move that microphone over or you're going to have to come up to a podium because the court reporter's not picking y'all up. I'm not sure how long that cord is, but do your best. All right, who do we have, Mr. Cobb? I'm sorry.
Judge, we have State versus Kiana Tate.
Okay.
This is 2025 CF 618. I'm not too sure. I understand it's got a track because this is a fugitive warrant case, but there aren't any pending charges or anything with regards to the 2025 CF 618 case. Her main case is the 2025 CF 1016.
In front of Judge Stone.
Right. And so I know that there's a possibility that probationary pleas are going to be made in these cases. And I wanted to handle her stuff here today, but I got one case with Judge Stone, and I really don't have.
What typically happens in these out-of-state fugitive is it just stays on the docket until they get transported, and then it gets dismissed by the state. Correct, Mr. Sheik? So it's just the situation is she has an out-of-state warrant, but she's got to resolve her cases here or bond out here before that will be handled. I think we've got an issue with a potentially, I think it's a co-defendant as well.
So I'm going to try to advance her substantive case so I can get it resolved so she can get the warrant taken care of and go back to Kentucky. And I've talked to the prosecutor over there in the South End to get that advanced, hopefully next week. So I guess we just leave this on the docket, and then I can try to resolve the substantive case, and then your case will go away.
When is that case set?
Well, it's not set until July, but I don't want to wait till July because she's just sitting there and she can get it resolved. I'm going to try to get it early advance next week so I can get it resolved.
Oh, yeah, see, it's a felony plea day in July still.
Right. But an information's been filed, so I should be able to ask for it to be advanced. If probationary offers are going to be made, that would be the way to resolve it.
Oh, yeah, it looks like it was transferred from misdemeanor court.
Yes, Mr. Mall, I believe, filed a direct file KPS, or direct file information.
All right, so what date would you like me to put it on?
Just a continuance to the next pretrial date.
All right, August 27th. This date will be your next court date for me, but it sounds like there's a chance everything will be resolved and you'll be on your way before then. All right, thank you, Ms. Tate.
Check your nose things out. Okay. All right, Judge,
She's got some other open misdemeanor cases too, so as far as.
I thought they were all transferred up. I'll have to look at that and see.
I've got you listed on 25 MM 988.
Yeah, I thought those were all part of the ones that came over.
A 1028 and a 1029. Oh, no, they do say, they say transfer, but they still say open. So you're correct on that, Mr. Cobb. I'm seeing two different things.
Yeah.
If they're transferred, they should be closed.
Those are my cases, Judge.
All right, thank you, Mr. Cobb.
Have a good day.
Have a good day. We'll see you on Monday.
This is Destiny Jackson, 24 CF 852 and 24 CF 1681. This is when we had the motion to unseal the search warrant. The state has stated last week that they don't have an objection, so I'll get an order to the court. I think I'm also waiting on cell phone downloads. That was mentioned at depositions from the state.
There's no objection, Your Honor.
I think once we get that, I can get these cases
What's
resolved.
the delay in the cell phone downloads? We talked about that last time, too.
The officer stated at depositions that he had to try to get it to the state, so I'm not sure where they are in that process during depositions.
There's a cell phone download that hasn't been turned over to the state yet?
That's what the officer said.
What agency is that?
Crestview PD.
Y'all didn't know there was a cell phone until the depositions back in April?
That's what
I didn't know, Your Honor.
That-
Yeah.
That's what I found out.
Ms. Leone, I think it's pretty clear what the issue is at this point. I'm just trying to verify
Yeah.
It's a
that.
constructive possession case, and obviously the state's saying that that's what they're using to try to prove possession, but we don't have that information.
Well, I think maybe a discussion with the agency as to why they're not turning over cell phones to the state as far as evidence is probably needs to be had. Especially because now it's been over 2 months since that deposition happened. Ms. Leone, you're agreeing to the motion to unseal the search warrant, is that what I heard?
Yes, it is, correct.
They just send me an order like we talked about on
Yes,
the
sir.
other one. Are you asking for the August 27th?
Yes, sir, and as I told my clients, if I can get that stuff done and maybe get some motions filed, I'll try to get an early court date.
So we can cancel the July 31st hearing?
Yes, sir.
You can just go ahead and mark that canceled.
And then,
8/27 at 9 o'clock.
all right, thank you, Your Honor.
All right, thank you, Ms. Jackson. All right, sorry about that. This is Ms. Odom.
Yes, this is Jennifer Odom, 24 CF 378, 24 CF 120. We have depositions, hopefully final depositions on July 1st.
What are you asking?
As for continuance, and obviously if I can get it resolved earlier, I'll move it up earlier.
Okay, because I think we've got that. I don't like to put too much on jury review that's not going to trial, but if it's a situation where there's a resolution that involves
Yes.
release, then you can certainly put it on
Yes,
that
sir.
date.
Yes, sir.
Which will be the 11th.
Okay,
I don't think I have any other criminal dates that week.
yes, sir.
Could be wrong. I do have an arraignment docket on the 10th. We could potentially put it on. All right, so let's put it August 27th with the possibility of a sooner date.
Yes, Your Honor, thank you.
All right, thank you.
And the last one I have is Jeffrey Todd Wagner, 20 CF 380, 24 CF 121, and 24 CF 122. I was at the jail last night until 7. I've talked to the state about this case. This is Mr. Sheik's case. If we could leave him set Peter C for docket day, we've talked about resolving this. I've talked to him about resolving this. I've made a counteroffer to the state. I think we are actually close to getting this one resolved. It's just getting the actual number.
My quote in my notes from what I said was absolutely last continuance.
Yes, sir.
So it'll be plea trial.
Okay. What dates will that be, Your Honor? Trial week?
Trial weeks are the 14th and the 21st. I've already given Mr. Cobb kind of first dibs on the 14, 15, 16 of that
Okay.
week because he asked for that last time around.
All right, and then docket days on Monday, correct?
Docket day is Monday, the 30th, but the jury review is not till the following Friday,
Okay.
which is I keep forgetting what this date is, the 11th. All right, so June 30th for docket day.
Yes, sir.
And we'll set the trial date from there.
Yes, sir. I think that's all I have.
Thank you, Mr. Wagner. We'll see you next week.
David Bradley is before the court in 2025 CF 1841. Your Honor, I'd like to leave this set for plea or trial. We're ready to try the case. The state has made a probation offer, and I'll review it one more time, but my client has declined.
Bradley, correct? This is a second-degree felony for Mr. Bradley, correct?
It is.
All right. So, Mr. Bradley, I just have to tell you these things. We'll talk about it more as we push towards that actual trial date. But do you understand that a second-degree felony is punishable up to 15 years in state prison? Has that been conveyed to you? Okay. Just, I'm not saying that in a way as to indicate what I would do after trial. I just have to make sure you understand what the maximum penalty is. Okay. So it sounds like Mr. Riasti is going to come out and talk to you again, but otherwise we're going to see you on June 30th, which is next Monday, to determine if it's going to be a plea or trial. All right. Anything else from Mr. Bradley?
No, Your Honor.
All right. Well, then we'll see you back on June 30th.
The jail, physically. Your Honor, Ms. Medina is going to enter a plea. If I might approach, though.
Yes, sir. Oh, I thought you.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Cyclone Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin.
All right. The microphones don't work when the static is on, so I just want to make sure it's picking you up.
Joseph Riasti for Stephanie Lynn Medina in 2025 CF 7 and 2025 CF 1026. The Office of Regional Conflict Counsel has moved to withdraw from 2025 CF 1026. And currently, if the court has a
I've seen their motion. I'm going to grant their motion, allow them to withdraw and appoint you, Mr. Riasti. I thought I saw an order for it, so I may have already actually signed it, but because I feel like I've looked at it already, but because I remember Ms. Medina's name, and I just, it may not have gone through yet. It's the processing issues we've been talking about.
with the understanding that that her representation has been resolved, the issues of her representation are resolved. We have a plea agreement that's been signed, and if I might approach, Your Honor.
Yes.
Make sure it's signed by the state.
Is there a, do you have the information?
And there's a copy of the score sheet and the information.
Perfect. All right, come on up. Mr. Sheik, this information's been filed, it just hasn't been processed to appear on the docket yet?
Correct.
All right. All right, Ms. Medina, can you raise your right hand to be sworn? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Can you state your full name and date of birth, please?
Stephanie Lynn Medina, January 14, 1987.
All right, and Ms. Medina, you're here in 25 CF 7 with counts of felony petty theft as well as possession that is fentanyl or methamphetamine.
That's how the information read, Your Honor.
Okay. And also in 25 CF 1026, which is another felony petty theft. All three of those cases or charges are third-degree felonies punished up to 5 years in state prison. Do you understand that?
I do.
All right. I've been handed a plea and sentencing agreement that would have you plea as charged as each of those counts. There being adjudication of guilt on all counts, which would be 3 felony convictions, 3-year state probation. That would be concurrent across all 3 counts, 615 court costs. As far as the public assistance defense fee, I think it's $150 for the first case, $100 for the next, because there's only one application fee. Restitution of $3.59 to CEFCO, no trespass at the Publix or CEFCO. Anti-theft class, 6 months driver's license suspension due to the possession charge. Substance abuse evaluation and recommended treatment. That evaluation would have to be done within 30 days of your release, which would be today if this goes through, and then treatment to begin within 60 days. Is that your understanding, Ms. Medina?
Yes, sir.
Is that what you want to do today?
Yes, sir.
Did you go, is that the state's agreement? All right, and did you go over this plea and sentencing agreement with your lawyer, Mr. Riasti?
Yes, sir, I did.
Okay, and did you understand it?
I did.
Did you sign it?
Yes, sir.
And are you satisfied with your attorney's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns? Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea? You understand by entering a plea there won't be a trial of any kind on any of the cases or counts. And you understand that you're waiving your trial rights, which are on page 2 of the agreement that you signed. And you understand that you're waiving any potential defenses that you may have. You understand that if you're not a U.S. citizen, this could lead to your deportation. All right, have that. Tell that to everybody. All right, and what is your plea to the 2 counts of felony petty theft and the possession of fentanyl or methamphetamine?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given, adjudicate you guilty, all cases, all counts. As charged, 3 years state probation, concurrent on all counts, 15 court costs. Can you do concurrent court costs? Okay. Concurrent court costs, $150 PD fee on the 25 CF7 case, $100 PD fee on the 25 CF 1026. That's because the extra 50 is for the application. You don't have to pay for that twice. No trespassing at Publix and CEFCO, $3.59 restitution to CEFCO. You have to complete an anti-theft class, 6 months driver's license suspension. Okay, I'm announcing this. She has to make sure she's hearing it. Substance abuse evaluation and recommended treatment, evaluation within 30 days of release, treatment to begin within 60 days of release. Due to the fact that you were determined to be indigent, Ms. Medina, I'll waive the cost of supervision with probation. This appears to be a guideline sentence. As Ms. Medina, you had a total of 23.20 points. Probation first. Okay. Talk to probation first. Once you finish with them, you're going to be fingerprinted up here with the bailiff, and then you'd have 30 days to appeal your judgment and sentence.
Okay, thank you.
Your Honor, could you announce that she has until tomorrow in the morning to report in case because she's going to be
She's going to
proceeding?
talk to them right here, and then they're going to instruct her on when to report.
Yes, Your Honor.
Okay. I mean, I would assume she'll be out sometime today, then
Yes, Your
report
Honor.
tomorrow morning if that's typically how it's done.
That's all I have before Your Honor.
All right, thank you. Mr. Williams? Charles Williams?
Charles. All right, we have that problem at the jail.
Your Honor. Have State of Florida versus Jack Barr. It's 24 CF 2616, 22 CF 1851, and 23 CF 1016. Your Honor, I'm going to request a competency evaluation. I'm not sure if I need to do that and to make a motion to you and send you an order to sign, or how, the details of that, but that's where I'm standing right now. Okay. In the meantime, while that's being worked, Ms. Leone and I are going to schedule some depositions in the case.
And which one?
In the newest case, Your Honor, because the other ones were done by previous counsel.
That's what I'm asking.
Yes.
I'm not familiar with it enough. I mean, I know the cases are related, but
Yes, yes.
one's much more recent.
BOP is not play. The 22 case and the 23 are not real players on the substance of the 24 case.
Well, but my understanding is that the alleged victim in the 23 case is the subject of the 24 case.
So it
yes.
may be subject to some Williams Rules stuff.
I just, what I'm asking is just, are the depositions done on every case but the new one? And that's what it sounds like. You weren't there for those, Mr. Williams, but the
Yes,
state is
Your Honor.
aware of them.
Yeah.
Correct.
Okay. All right, but I would need a motion and an order on that, Mr. Williams. What date are you asking for? Are you just asking for the next pretrial?
Yeah, I think just to keep it moving.
All right. August 27th. I surely hope that if we get an order signed in the next week or so, that should be done by August 27th. All right, Mr. Barr, we'll have you back on August 27th at 9 o'clock. You're going to speak with a doctor in the meantime.
Thank you, Your Honor.
All right, thank you. Have a good day.
And, Cochran. Your Honor, we have Timothy Cochran, that's 24 CF 2690. This is with Ms. Berwickman. Your Honor, I noticed that there previously, before I got on, there was a motion filed to depose the minor child. That motion has not been acted upon. So one of the things I'd like to do today is set that for a hearing. We may not end up needing that hearing. Ms. Berwickman and I are going to confer about some matters. But I think if we set it, and if we don't need it, we can always call your JA and cancel it. So that's one thing right there.
How long do you think that motion would take?
It shouldn't take long at all, Your Honor.
Probably no longer than 10 minutes.
15 minutes at the
I assume
most.
so. It's not really an evidentiary issue
Right,
for
no.
the most
It's
part.
just asking you for the permission to depose as required by the new rule. And other than that, Your Honor, we have Ms. Berwickman and I this morning discovered that there may be some discovery that I don't have, no fault of hers. I think I may have not downloaded it properly, but it has to do with the child's CPT that was done in Alabama. So, which I wasn't aware that Ms. Berwickman had. So.
I sent an email to my secretary.
And we're going to get together. I'm going to get that. And, frankly, Judge, that may even obviate the necessity for the hearing on, to depose the child. If it does, we'll cancel that. So I just asked to come back on, as a quick tracking date, August 27th, I guess, is the next.
That's the next pretrial date, but if we're going to have a hearing on the child witness issue, then let's do that before then.
Correct.
Since it's short, I could put you on July 10th, if needed. I don't want to bring you all in for a day that you're normally not going to be here, but
I think I have a jury trial with Judge Clark on that date.
about July 31st.
31st.
And again, this is only if needed. As you said,
If
it might not be needed. I'm assuming the state opposes the motion.
Yes, Judge, at this point.
Okay. All right, so let's put it on July 31st. Or that on the afternoon for 2 o'clock.
2 o'clock.
All right, so it'll be the 7/31 date for the motion, 8/27 for pretrial.
Yes, Your Honor.
Who's next?
Yeah, Jerry.
Because bond was revoked.
Your Honor, today, Mr. Moody would like to withdraw his previously entered not guilty plea and enter a no contest plea to the count in the case, and that's a count of grand theft auto, which is punishable by a maximum of 5 years in the Department of Corrections and up to a $5,000 fine. In exchange, adjudication will be withheld. He'll be put on standard probation for a period not to exceed 2 years, and a restitution of the case will be reserved for 90 days. And I have that if you'd like me to pass that up to you.
Okay. I think the PD normally does that. So. There's more work for the clerk.
Mr. Moody is not visitation.
Sorry, Your Honor.
All right, this calls for probation. I see that he's got another pending misdemeanor case in front of Judge Ward that's set for court next week.
July the 1st.
I just want to make sure it's clear that if he hasn't posted that bond, he's not going to be released today unless he posts that bond.
He understands, Your Honor.
Mr. Moody, can you raise your right hand to be sworn? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Jerry Albert Moody, July 12th, 72.
All right, and Mr. Moody, you're here in 25 CF 657, charged with grand theft auto, which, as your attorney announces, a third-degree felony is punished by up to 5 years in Department of Corrections. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement between you and the state that calls for you to plead no contest as charged. It's a withhold, is that right?
It is, Your Honor.
Okay. 2 years of probation, reserve on restitution for a period of 90 days. Are there any other terms of the probation?
No, Your Honor.
Just probation to stay out of trouble, meet with probation.
Yes, sir.
And restitution once it's paid. All right. Is that what you want to do today, Mr. Moody?
Yes, sir, Your Honor.
All right. Did you go over this? It's listed as a sentencing recommendation, but it's a plea and sentencing agreement between you and the state. Have you gone over this with
Yes,
your
sir.
lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Is there a score sheet? I'm assuming it's a withhold. It's probably a guideline sentence,
I
but
think it was a total of 28 points.
28 points. Okay, if y'all could get that to file while I'm going through the rest of it, I just want to make sure it's not a downward departure. It's just other things we have to talk about. All right, Mr. Moody, are you satisfied with your attorney's advice and representation in this case?
Yes, sir, Your Honor.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir, Your Honor.
Are you currently suffering from any mental health issues or concerns?
No, sir, Your Honor.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir, Your
Has
Honor.
anyone promised you anything in return for your plea?
No, sir, Your Honor.
And do you understand if you enter a plea, there won't be a trial of any kind?
Yes, sir.
And you're giving up your trial rights, which are on page 2 of the document that you signed?
Yes, sir, Your Honor.
And do you understand you're waiving any potential defenses that you may have?
Yes, sir, Your Honor.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir, Your Honor.
Okay. And what is your plea to the grand theft auto third-degree felony?
No contest, Your Honor.
I'm going to accept your no contest plea as freely, voluntarily, knowingly given. Withhold adjudication, probation for 2 years, or restitution, reserve as to the amount for 90 days. And then court costs will be $515. And waive cost of supervision due to the fact that you're represented by, are you privately retained?
No, Your Honor.
Okay, so it's appointed.
I'm appointed.
Okay, based on the fact that you've been determined to be indigent, Mr. Moody, I'll waive cost of supervision. Just waiting on the guide. I've been told this is a guideline sentence. I don't have them to look at yet, but they're printing up right now. Yes, sir. Slow down. You don't have to rush. Not going anywhere. That's all I need is someone to trip in the well. Yeah. So, all right. This 28 points on the guidelines as stated by Mr. Williams. I need you to talk to probation, Mr. Moody, and then I don't think I need fingerprints because it's a withhold, but you have 30 days to appeal the judgment and sentence.
Your Honor, State of Florida versus William Talbot, 22-2507, and that there's a 20 case also. I'm sorry I didn't write it down, Your Honor.
I've got 2020 CF 2925.
925.
All right. What are we doing with Mr. Talbot?
Your Honor, this first time up for me. I know it's an old case, very old case.
You just got appointed last month, I believe, Mr. Williams.
Yeah, May the 6th, I believe is what I have, Your Honor. I have to get the depositions that were previously done by Mr. Nopes in the case so that I can get them out with my client, review them, that sort of thing, and then engage in some conversations with Ms. Leone about how we're going to go forward. So I'd request a continuance to that August 27th date.
Understand that, Mr. Talbot?
Yes, sir.
All right. August 27th at 9 a.m. will be your next pretrial conference.
Sir. Thanks. That's it. All right, I'll be out there.
Your Honor, next we have State of Florida versus Corey Valley. That's 23 CF 1996. And
you are in the meeting.
Sorry.
Ms. Bliss and I can approach.
Yes.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store.
All right, Mr. Valley, so there's just a little bit of
in,
confusion regarding
your
your
health, we'd like to invite
indigency
you to
application.
stop
It
by.
looks like Judge
We're located
Contera
in
could
Fort
previously
Platte.
found that you weren't indigent, which means you wouldn't be entitled to appointed counsel. That happened in October of 23, and you were represented by the public defender for quite some time after that. And then now Mr. Williams has been appointed as your lawyer. So I'm going to have to review that issue. So what's going to happen is Mr. Williams is going to come out and have you and go over the application with you, have you do a new one, because obviously things have changed over the past almost 2 years, I would guess. But if you will fill that out, he'll turn it in. If you can make sure we get a copy to my office, that way I can take a look at it before the next court date. Otherwise, I may not see it. And then we'll come back on June 30th, and I'll make a determination of whether or not that you qualify to continue to receive appointed counsel. because of some things I saw on your previous one. If that's still accurate, then you probably do not qualify. And I understand that you've got some obviously some issues, and you've been in jail for quite some time. But if there's income that's sufficient to get you over that level, then you wouldn't qualify anymore, and you'd have to hire your own counsel or go forward pro se.
Well, it's not income, it's when we did the math at the stuff that I paid every month.
Okay, well, it's about income. It's, basically the rule is, double the poverty guideline, dependent on how many dependents you have or not. So I'm going to have Mr. Williams fill that out with you, get it signed, get it filed, and we'll talk about it on Monday. June 30th for status on that issue.
Your Honor, that concludes my business.
All right. Thank you, Mr. Williams.
Yes, sir.
All right. I think we've got Mr. Powell. And Mr. Maddox, I'm going to call you up about that case that I think they brought to your attention.
Oh, yes, Your Honor.
Well, we can do that at the bench.
Thank you.
Go ahead, Mr. Powell.
Alicia Johnson, Judge. It's
I'm fine with.
two cases, 24-2693 and 25-324. Hey, Felicia.
Was she on yesterday's docket?
No, I don't think so, Judge. I was here yesterday. I don't believe it was.
Oh, here it is. Never mind. I apologize. Go ahead.
We've got all the victims in this case has been arrested. I believe all of them have. Mr. Williams is representing one of them. He's got deposition set for July the 8th of 16 people, but there's a couple of them that I want to take, but there's only 10 minutes set for each, so we're going to try to get that moved around. I've talked to the state about it. We need to continue it to August because this is a complicated case. It's been continued one time before.
Yes, I see this is the second pretrial. My question was going to be about setting depots because I didn't see anything had been set, but again, I'm not seeing everything in kind of real time like I'm used to. So, Ms. Leone, any concerns with that?
I was going to just mention, part of my discussion with Mr. Powell about the depositions was the fact that they've been set by Mr. Williams on a co-defendant, and Mr. Powell believes that the time reserved by Mr. Williams for each witness would not be enough time for him to also question witnesses. And I was asking to better coordinate those efforts because it would save time in the long run. Also because I wouldn't want to subject the victims to several depositions, one per case, basically.
Okay. Well, we obviously have to do a better job of coordinating with co-defendant counsel. It's just something that needs to be done.
If I can have the name of my client, I just picked up on the conversation 5 minutes, or is it the other Mr. Williams?
I think it's the other Mr.
It's
Williams.
Mr. Charles Williams, yes.
I think he pointed when he said it, Mr. Williams. That's why I knew who he was talking about, but.
I was buried in my work. I just heard the name.
Judge, can I take this call just as Bo called it? He was coming on his way. He's been in depositions in the Funiac.
Well, why don't you take a break and figure out what y'all want to do about these depots, but I can't have you taking phone calls in the well.
Okay. I got you.
So we pass the case.
We'll pass it, and we'll call it back up
when
when you're done talking to the other Mr. Powell.
Got you. Thank you.
Thank
Judge.
Thank you.
Judge, would it be possible for him to appear before you this afternoon? He's on his way back from the Funiac.
Yeah, that's fine. I mean, if he wants,
There we get you.
about that case?
Yeah.
Yeah, that's fine, if you all want to talk about it.
Justin Buzzley case.
Busby, we want to talk about that. Who's on Busby? Yes. Because I think your office had indicated that Mr. Bo Powell cannot be here on Monday when I said he needs to be here to talk about it. What about Ms. Carter?
I don't know anything about it.
Mississippi, I don't know if Zoom might be an option. I don't want to speak for her or for the court.
Well, I need answers on that case. So if he can be here this afternoon, we'll certainly take it unless Ms. Basso, you expect you won't be here this afternoon.
I'd rather be done, but I will be here
I just want to take care, because that's an old case. We talked about it yesterday. It's not your case, Mr. Powell. It's Bo Powell's case, although there's another lawyer who's listed as the attorney of record on it. I've got some concerns that it's just hasn't been resolved or set for trial or anything else at this point. So
He might be here before you break for lunch.
okay, well, if he can get here, we'll take it. All right, but we'll call you back up with Ms. Johnson once you've got that figured out. All right, Mr. Maddox, can you approach?
Yes,
And who's on that case? Is it Mr. Sheik? Yes, Your Honor. Mr. Sheik, if you could come up too.
I'm Amanda Gaskin with Where I Press Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire. Take one. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa!
Not cool, bro. I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath.
All right, so
Call
Lieutenant
Coy.
Kane, it's 25 CF 782. We're going to place him on August 27th at 9 o'clock, but if the evaluation comes back sooner, we can get it on an earlier date. So he's good to go. All right, Mr. Nopes, are you ready? Do you have Mr. Nopes?
Judge, this is Marcia Alicia Knox, 25 CF 92. She's also listed as Reed, 22 CF 1353. It's my understanding she's retained. Ms. Dudley.
Yeah, I half out on it. I didn't get notice. I didn't know.
Okay.
We realized when I was at the office and I came back.
I will tell you, Judge, I looked yesterday and
Just haven't
her notice
processed
of
yet.
appearance is not registered. But even though I could go back and look at the email that I received.
And I know I brought it up a couple times yesterday, but I know, Mr. Nopes, you were in Fort Walton in court in the early portion of the docket. But my understanding is there is a logjam of pleadings and docket entries that have not been processed. I can tell you for sure there's been at least several continuance orders that I signed over a week ago that still aren't displaying. And I've heard about it as being as much as 2 weeks. So I would suggest all lawyers double check and have your staffs double check to make sure everything that's been filing is showing up on the docket and it's been received. I know one of the concerns is that if defense lawyers are filing written pleas of not guilty and waivers of arraignment, thinking it's going to take off the docket, it may not.
Correct.
So my concern is arraignment dockets are going to come up, and I'm going to get 12 cases I got to put out of capias, even though there's been a plea of not guilty filed that I can't see. Because I know we had at least one case that was on the docket, Mr. Patel's case, that I had signed an order, continuance case, at least 7 days in advance, and it still wasn't showing up. So.
Yeah, we went through the docket this morning for Raymond to make sure we didn't have anybody.
All right, so just everyone double check those things. But so what do we want to do with
I'll
this?
ask for continuance
Knox / Reed.
so I can get discovery and
Okay.
start working on the case.
Let's see. The one's just from January, and the other one's that's the VOP. Okay. This is the second time up, so I'll grant your continuance request, Ms. Knox or Reed. I'm not sure. Is it just because of the time difference between the VOP?
Yeah, I think my VOP is up on the Reed and my new charge is up on the
You changed your name after you went on probation, I guess? Or no?
It
doesn't matter. I should probably stop asking questions.
Yeah.
All right, 8/27. We'll see you August 27th will be your next court date, Miss Reed. Obviously, Miss Dudley, if you get something figured out with the case and get it resolved, you can bring it on a sooner date.
Your Honor, 1 second. This is the third co-defendant with Ms. Streeter and Ms. Johnson, represented by Mr. Williams and Mr. Powell. So the issue of depositions, they've been set already. However, I don't know if we need to coordinate again because of your.
I'll just see what it is. If I can be there, I'll be there.
I think the concern is there's not enough time
That's what Mr. Powell told me.
where each deponent is listed for 10 minutes, and to be questioned by 3 lawyers and potentially the prosecutor, that's not going to be enough time. So if y'all can maybe get together and reschedule those, but that's Mr. Powell, Mr. Charles Williams, and you now,
Yes,
get those things re-coordinated so you can do it one time.
Okay, we will.
All right, perfect.
Thank you.
Okay. That's all I have up here.
All right. If you're sure this time. All right. Sounds like we've got Mr. Parker next.
Judge, Mr. Parker has 23 CF 1799, 24 CF 1239, 24 CF 1816, 24 CF 2449, 24 CF 2902, and 25 CF 518. Judge, I had the court appoint an investigator who has met with Mr. Parker, and he and I, the investigator, are scheduled this afternoon to chat about the case. We are in the process of setting depositions in all of the cases. It's just a lot of different case numbers, and he's got several misdemeanors.
Leone?
Depositions have to be done yet. The cases are not terribly old, but they're too many. So I would like to get to a resolution as soon as possible.
He's got the 2 VOPs and his oldest new law violations from July, so that one's almost a year old, and then October, December, and March. So there's quite a few cases that need to be worked. So I'll give you August 27th, Mr. Nope, so let's try to make some progress.
Sure.
I know it's hard, even if you got everything done on the older cases, I'm sure you're trying to get some sort of global resolution on these. But there's 5 or 6 pending cases, 6. And you said there's misdemeanors too?
And the problem is that he would be willing to plead to the misdemeanors, but it's going to violate his probation.
Okay. Well, see if you can get them all resolved, and I think we've talked about, are those Judge Ward's cases? Like you might have more than 2.
He has 3 misdemeanor cases, 4 misdemeanor cases open.
Yes, I see 4. If y'all have some sort of global resolution, Judge Ward has told me numerous times in the past, we can resolve those in this court as well, just so he's not having to plea out in 2 different courtrooms.
Yeah, I know. He's charged with arson and then also.
I'm just putting it out there.
Yeah.
Trying to save time where we can. All right, 8:27, 9 o'clock.
Absolutely. I believe that's all I've got, Judge.
All right. Thank you, sir. All right, I think I've got, let's bring in Mr. Ramey. Can I get that bell for Ramey? All right, Mr. Ramey, can you hear me okay?
Yes, sir. Good morning, Your Honor.
All right. We're here on Ms. Bell's case. This is 25 CF 617. I think all we have is the out-of-state fugitive issue, but she's got pending cases in front of Judge Clark and in county court as well. So,
Judge, the petty thefts have been moved into a felony count. I think that's 25 CF 1015. Been working with the state attorney's office to try to get that case resolved. I think we'll be able to resolve that soon. I know today's not the day for that, but I just wanted to let you know what's going on in that case. So he's not ready to go back to Kentucky on the extradition warrant, but I'm hoping by our next court date we'll have the felony case resolved and be available to be transported and extradited.
all right, it's my understanding that once she gets transported, that this case will be dismissed by the state. It's just kind of a placeholder until that's resolved. So once you get those cases resolved, make sure you talk to Mr. Sheik, who's the prosecutor on this case, and I'm sure they'll enter a written null pros or dismissal once everything else is resolved and she's transported.
Yes, sir. That's what the prosecutor indicated to me, and I was hoping to get it done by today, but we're unable to get the paperwork done. So hopefully we'll get it done soon.
All right. Anything else for you, Ms. Bell? Okay. All right, Mr. Ramey, anything else?
No, sir. Thank you very much, Judge.
All right. Thank you. Have a good day.
You as well, sir.
Okay. Who's that?
Mr. Sledge, too.
Oh, here she is. All right, Ms. Brumbaugh. A VOP? Morning.
Good morning.
Are you Jennifer Brumbaugh?
Yes, sir.
All right, you're here in 21 CF 1397. It appears to be a violation of probation. But
Yes,
you
sir.
don't have a lawyer.
No, sir.
Can you afford a lawyer?
No, sir.
Okay.
I mean, I've pretty much completed everything.
Okay.
I just didn't have it completed.
Well, have you completed everything?
Yes.
All
I have
right.
completed everything. I have like.
Can
my letter
probation
from my
take a look at
attorney.
what she's got and see if y'all can determine whether or not she's finished? I can't read it from here, Ms. Brumbaugh. So, no. Just, Ms. Brumbaugh, just take a breath real quick. It's okay. We got plenty of time. That's why I can see you're getting kind of anxious, so I'm just trying to calm you down a little bit. It's okay. Can probation talk to her to look at her paperwork, see if she maybe have everything done, and if we can get this resolved today? And then we'll just call you back up once they've had a chance to take a look at it and maybe contact their office to see if everything is good to go. Mr. Kleins, are you ready?
I got you. Mr. Arp. Your Honor, this is Mr. Arp. In May, I had filed a motion to declare the unlawful use of a two-way communication statute unconstitutional on vagueness grounds. That motion is being set for a hearing in the month of July. We're just waiting to hear back from the clerk so we can put it on that docket. Other than that, these cases are ready for trial. And so I would ask the court for a continuance so we can get that motion heard, but then the plan is to try the case in the month of August.
Say again, Ms. Berrickman.
That works for the state.
Okay. So y'all haven't figured out what date in July yet?
Whatever the court's miscellaneous date is.
I think it's July 31st.
I think it is. Like I said, my assistant's already reached out. We're just waiting to get confirmation back from the clerk's office. As soon as we get that confirmation, we'll notice it.
I saw your motion yesterday. I started reading it, but I just didn't have time to really jump into it in depth last night because since we were here until 5:30 last night too. But and it wasn't set for hearing, but I saw it, and obviously it was intriguing to me to see what it was all about.
In full candor, I'm going to be filing. Also, since I don't want to delay the case any longer than it has to be. There's probably going to be most likely a motion to declare a 6-person jury unconstitutional. I'll file that. That particular motion, I don't really have a lot of argument on. It's a 12-page motion, but I want to get the motions heard so we can get this case set for trial.
Okay.
I would just ask with everything going out the clerk's office, if you could just send those to me directly to make sure I get them.
Oh, yeah, absolutely.
And then if the state has any sort of response or case law or anything, make sure that gets to me in advance of the hearing so I can read everything and hopefully make a decision, because declaring a statute unconstitutional takes some special measures. Obviously, the state is on notice because the state attorney for this circuit is on notice. I just want to make sure that we're looking at everything that needs to be looked at, and I can read it in advance and be prepared.
Absolutely. Yes, sir. And I've talked to Mr. Arp at the jail and advised him this has to be set for a hearing, so he's aware of this.
Because otherwise, that's only one count of one case, so he'd still be going to trial in September on the other.
That's correct.
Okay.
Yes.
Are you aware of any other courts making that decision on this case yet? I tried to quickly research it when I saw it, but I didn't see anything pop up.
I am not aware.
Even at the circuit level?
If I can find something, I'll certainly. I've been dying to get this thing to a hearing. So.
You're giving me a chance to be the first. Appreciate it. All right, so Mr. Arp, we'll see you back on, it sounds like July 31st for the purposes of those motions as far as the unconstitutionality of the particular statute under which you're charged, as well as the jury trial or 6-person jury. I haven't seen that one. That's not filed, right?
It is not filed.
Okay. If you, when you file it again, send a courtesy copy to my office to make sure I see it.
As the more I've been listening to what's going on, the more it's just occurred to me, maybe we should be just emailing everybody directly at this point until things get cleared up.
My understanding is the e-service portal is still getting everything to everybody, but I'm not on that.
Well,
otherwise, I'd have 1,000 things a day come through.
I don't want to burden your email address too much, but if the three of us can't see what's going on, that's the most important thing.
Yeah, just on stuff like that, especially non-garden variety motions.
Absolutely.
Make sure I get a copy of that, because I like to read them in advance and kind of digest them until we get to the hearing and see if I come up with something different. It's just the way my brain works. So.
I might get that motion filed later this week. Frankly, it's a motion I've used for years. So It's just a matter of changing some things and getting it filed. So I'll get it filed.
Okay. All right. So then we'll put him on August 27th for his next pretrial.
I'll come see you at the jail before the hearings. Okay?
All right. Thank you, Mr. Arp.
Your Honor, this is Mr. Kelvin Brown. I've already talked with Mr. Sheik. We are hopefully going to have this resolved next Monday if we can leave this on for plea or continue for the 30th.
Is that accurate, Mr. Sheik? All right, so Mr. Brown, we're going to put you on for next Monday. That's the 30th. Sounds like they're hoping to have it resolved at that point. So if not, we'll discuss where it's going to go from there. I know Mr. Climes was just appointed to your case recently, so we'll talk about what needs to be done if it isn't resolved that day. All right. Thank you, Mr. Brown. We'll see you on Monday.
All right, man. Your Honor, this is Mr. Dandridge. We did file I'm sure you haven't seen it, but we did file a motion to withdraw from Mr. Dandridge. I can give the court the filing number if the court wants.
I've seen the motion. I think I looked at it I know it was emailed the other day, so I have seen it.
I believe it was last Thursday or Friday.
I think it was Friday.
Yes.
Looks like I have an order. I just need a name. Can you give me case is it? you have an email address I can put on for him? Mr. Nope's leave? All right, so Mr. Dandridge, I'm signing the order right now appointing Marty Nopes to your case.
Yes, sir.
Unfortunately, he was here. He just left probably in the last 10 minutes or so. But once he gets notification of this, which we'll try to email directly to him to make sure he gets it quickly, he'll come out and see you. But we'll have to pass your case, obviously, because you don't have a lawyer at this point who's here.
Yes, sir.
All right, so we'll put on August 27th at 9 o'clock, and Mr. Nopes will come see you.
Your Honor, Mr. Hainish is present and approaching. He's in pretty much the same boat as Mr. Brown was. We were recently appointed.
In May. Yeah.
He does score a Department of Corrections sentence at this point. The state is considering an alternative to DOC, so I would ask the court leave him on plea or continue for next Monday.
Next Monday, June 30th, plea or continue, Mr. Hanish, so we'll see you in about 6 days.
Your Honor, this is Mr. King.
This is Anthony King?
Anthony King, yes, sir. I did file a motion to consolidate these two cases, and I believe the court has received an order, but I can't guarantee that. If you haven't, we'll email you one directly today.
Consolidate?
Yes, sir. The police reports in these two cases, this is all one continuing episode here. The same offense date, the same.
When was the motion filed?
Don't have the file with me. I would say it was probably filed 3 weeks ago.
Okay.
2 weeks ago.
I'm not seeing it in either case.
Okay. I'll email it to you today.
Okay.
Yes.
Does the state have an objection to the consolidation?
We don't.
Okay.
So we'll get it to you today with an order. We'll just
Okay.
email it directly.
Just make sure that you indicate in the email when you send it over that it's now stipulated by the state.
I'll go ahead and modify the motion so it's a stipulated motion.
Okay.
But I was hoping to get these cases resolved. Ms. Barrickman's idea of resolving them and mine are totally different. The state's current offer right now for Mr. King is 5 years in the department, followed by 5 years of probation. I relayed that offer to him. I know this is an older situation. I can't, in good faith, I can't advise him to accept that at this point. I would ask the court, if the court wants to leave this on for next Monday, we can do that, plea or continue. Or if the court wants to continue it to August, my goal is to, I know this is an older case, but my goal is to make it a not older case relatively quick. I know he's been in.
I'm curious to how you're going to do that, Mr. Clance.
Well, I can set it for trial. I just need to make sure that I have everything covered before I do that. I don't want to come in here and just.
But you're not doing that for this cycle?
Not for this cycle.
Okay. Do you think there's progress that could be made by Monday?
I don't think so. I think the better course would be to continue it. And I advised Mr. King, I said, if we can come up to, if we could reach an agreement, we will certainly advance this on the first available docket.
Well, again, y'all were just appointed to it in the past couple of months, I think, or no? Or at least you're new to it, Mr. Clance.
I am new to it, yes. That's why I don't want to say I'm ready for trial in a situation where the state's offer is 5 years in prison.
I understand. All right. Let's just go ahead and continue it to August 27th. If y'all do work out something or anything else is needed, there's earlier dockets than that. But if there's no progress that's going to be made, we're just making work for ourselves to bring Mr. King back on Monday if doubt he wants to be transported just for nothing to happen anyway.
I wouldn't.
All right, August 27th, 9 o'clock from Mr. James. Hopefully we can have some sort of resolution, and whether that's a plea or a trial next time around.
Yes, sir. Your Honor, this is Aaron Knopfsinger. We are in discussions with the state setting depositions, looks to be probably the second week of August for 2 witnesses. We, about a month ago, started the mitigation evaluation process for Mr. Knopfsinger. I would ask the court for just a 1-cycle continuance. My goal here is to have this case hopefully ready for trial before the end of the year.
Will not object to 1 continuance, Your Honor, otherwise it is pretty straightforward. He did confess often.
I think he's talking about mitigation, so.
But that's why I say if they need to get the mitigation report, we understand that. That's why we're not objecting to the continuance.
All right. August 27th, this case is getting on the older side, so let's see what we can do in the meantime, Mr. Kleins.
Yes, sir.
We'll be ready next time.
Okay.
If the defense is ready.
All right, I'll come see you at the jail. All right. Your Honor, this is Gerald Reynolds. He's on the docket as Jonathan Gerald Reynolds. I met with Mr. Reynolds at the jail twice. His name is actually Gerald Jonathan Reynolds. So I even thought about putting an AKA on here, but I figured I'll just try to make the minute sheet as clear as I can. Mr. Gerald Reynolds in 25 CF 773 is going to be entering a plea of no contest to the lesser included offense of misdemeanor battery. The agreed upon disposition is that he will be sentenced to time served. He would be assessed misdemeanor court costs, a $100 cost of defense, and he would be adjudicated of the misdemeanor. If I may approach?
Yes, sir. Is that the state's agreement?
It is, Your Honor.
All right, Mr. Reynolds, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Can you state your full name, since there's been some confusion, and your date of birth, please?
Gerald Jonathan Reynolds, 3/14/1988.
All right, Mr. Reynolds, you're here in 25 CF 773, currently charged with battery on a detainee, which is a third-degree felony punished by up to 5 years in state prison. Do you understand that part? All right, I've been handed a plea and sentencing agreement that calls for you to plead to a lesser included offense of misdemeanor battery. Terms of the sentence would be time served, misdemeanor cost of it's battery, 622. So even though it's a misdemeanor, because it's a battery charge, it gets, surcharges of 201 and 151. $100 cost of defense, and how much time do you think you might need to pay that off or set up a payment plan?
Your Honor, Mr. Reynolds is actually doing a 12.1-month sentence right now, so his expected EOS date is going to be sometime in the month of September.
Okay. So go ahead and send it to judgment, or what do you want me to do?
I would prefer if the court would consider giving him 90 days to pay upon his release. I don't know if the court wants to do that.
What I'll do is 60 days to pay or set up that payment plan with the clerk's office. You can do that. Otherwise, it'll turn into a judgment against you, which would cause issues with your driver's license and stuff like that. So make sure you take care of that, Mr. Reynolds.
Yes, sir.
Understand? Yes, sir. Okay. Did you go over this plea and sentencing agreement with your lawyer? Did you understand it?
Yes, sir.
Did you sign it?
Yes, Your Honor.
And are you satisfied with your attorney's advice and representation in this case?
Yes, Your Honor.
Are you currently suffering from any mental health issues?
No, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances? Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, Your Honor.
Has anyone promised you anything in return for your plea? You understand by entering a plea that there won't be a trial of any kind, and you'll be giving up your right to your trial rights, which are listed on page 1 and going on into page 2 of the document you signed. Do you understand you're waiving all potential defenses that you may have? I didn't say this before, but I believe your attorney did. It'd be an adjudication of guilt. Do you understand that? All right. And do you understand that if you're not a U.S. citizen, this could lead to your deportation? All right. And what is your plea to the misdemeanor battery lesser included offense? All right. I'm going to accept your no contest plea as freely, voluntarily, knowingly given. Sentence you to time served, 622 court costs, $100 cost of defense. I'm going to give you 60 days from the date of your release from DOC. That's where you're headed, right? Okay, just the 12.1. Is there anything else keeping you here? Are you heading anywhere else in the meantime? Okay, I just want to make sure because kind of scrambles everything if we don't know if there's going to be other locations. But I'll give you 60 days to pay once you're released, or set up a payment plan within that 60 days. Okay. Any questions? All right. Just need to be fingerprinted. This is a misdemeanor, so we don't need guidelines. And you have 30 days to appeal the judgment and sentence. All right. Thank you.
And this is Mr. Schmidt. Come over here. He has got two cases. One's a new law violation in 24 CF 2145. There is a VOP in 22 CF 416. At this time, I would like to set the 22 CF 416 for an evidentiary hearing.
I think it is, but he's on the phone, so. I'm just trying to find days.
Yes, sir.
How many witnesses would the state expect in the evidentiary hearing? Maybe two. We can put it on the 7/31 at 2 o'clock. Are you not here? Was the
31, if we can also avoid the 7th of August. I've already got several set that day.
do July 10th? Let's put it for 2 o'clock on the 10th. That work for you, Mr. Klein?
Yes, sir.
All right. So that'll be July 10th at 2 o'clock for the evidentiary hearing on 22 CF 416, and then 24 CF 2145 will track with it for status.
And while he's here, Your Honor, I know that Mr. Schmidt has been filing 3850 claims, and I know that the court denied the most recent one, I believe, in the month of April, late April. Mr. Schmidt wanted the court to be aware that he has recently sent the court another pro se motion. I know that we're having issues with the clerk's office, but I definitely want the record to show that at least a week ago, he mailed the amended 3850 petition to the court. I have provided him the address of the First District Court of Appeal if he wants to file it directly with them. But I just want the court to be aware that he has refiled another motion.
And that's in the 22 case?
Yes, sir, Your Honor. So, and I've advised him I will be trying to find where it is. It's not showing up in benchmark, and it's kind of disappeared into the void. But I just wanted the court to be aware that he has refiled it because and specifically he advised me that it was done within 60 days to comply with the court's timeline on the last order. So as soon as I find it, I will email the court a courtesy copy to make sure you see it.
Yeah, that was April 25th. I did the order striking the previous one as insufficient. If you get your hands on it, Mr. Kleins, if you could just forward me a
Absolutely.
copy, because typically we send those straight to one of our staff attorneys who looks them over as well, so that it can be dealt with in a timely fashion.
Absolutely, and that's why I wanted the court to be aware that it has been filed. I just have to track it down.
We'll see you back on July 10th, Mr. Schmidt, for your VOP.
All right, I'll see. All right. Your Honor, this is Robert Schofield. I'll have to look into it. Okay, this is Mr. Schofield, Your Honor. I know Mr. Schofield has a little bit of a history in this court. At this time, I believe the best course of action is to set 24 CF 1844 for trial.
Have you met with Mr. Schofield?
I have, Your Honor.
Okay, I just know there was previous counsel had been concerned about a potential competency issue.
I don't get that vibe from Mr. Schofield.
Okay, I just want to make sure it's addressed again.
No.
If you say no, then
I've met with him for probably 40 minutes, 45 minutes the other day. I'm aware that there's a lot of backstory to hear, but I also don't want to waive any speedy trial rights. I know he was convinced he was going to go to trial in February. So that's why I'm picking the oldest court, or the oldest case, to just go ahead and set for trial. In full candor, the state has offered him 6 months county jail. There very well could be a plea here, I don't know, but I also don't want to just kick this down the road. This is a felony petty theft. I mean, I can be ready for this, no problem.
well, the one thing I would mention, and I guess have the advantage on you, Mr. Kleins, of having been through all the court dates, is that Mr. Schofield has talked about videos and whether or not there's been videos or there might be other videos. So make sure you all are talking about those issues. Which one is the 1844?
It's the first one. Your Honor, the state would request if we could do 2080. That was the one that we were preparing for last time before Mr. Maddox was removed.
We can do that. That's fine.
Does that matter to you, Mr. Schofield?
No, sir, Your Honor.
Okay. So you're good with doing the 2080 case?
Yes, sir. And I'm going to go talk to Mr. Schofield later this week. And
if we do go to trial, the 6 months will be obviously off the table.
I would be shocked if it was still on the table.
All right, so you understand, Mr. Schofield, typically I don't take negotiated pleas after docket day, which is Monday.
He has been advised, Your Honor.
Okay. So anything after that would be as charged guilty pleas.
Yes, sir. Well,
Otherwise, it'll be a trial.
As far as I've been told by my two previous attorneys, that the video that they're trying to use is inadmissible because it's a body cam recording another recording. Is
Okay, no motion's been filed on that, and I know this has come up in the past, so.
My position on that type of a situation, Your Honor, is that's a trial objection. That is a best evidence objection. That's what he's making. There might be a motion in limine. If I file it, I'll go ahead and send the court.
I mean, you know my philosophy is always better to know what your evidence is before the jury's been sworn.
I would love to know all the rulings in advance. So but I'm fully aware of his best
Well,
evidence issues.
there's a mechanism to do that.
I know.
So, and
I'm a
I
big
always
fan of motions.
suggest people take me up on that offer. So, all right. So 24 CF 2080 will be set for trial. We'll come back on June 30th, which is next Monday. See if any progress has been made, and then the other cases will ride along with it for status and as control dates.
Okay. Thank you.
All right. Thank you, Mr. Schofield.
Your Honor, this is Mr. Gregory Spears approaching the podium. I have talked with Ms. Leone with the State Attorney's Office. I am working on getting this score sheet accurate to properly reflect what a guideline sentence would be. I would ask the court to leave Mr. Spears on plea or continue for next Monday. I'm very cautiously optimistic we can get something resolved next Monday, but at the minimum, I would like to be able to give him an accurate, this is what you're facing in terms of points here. So, but there might be a possibility he pleads next Monday if we can get something worked out here.
All right, but you're wanting plea continuance.
Plea or continue, yes, sir.
Hold on, there's two really old cases. Those are VOPs?
They have, yes, sir, Your Honor.
Okay. One's a 2012 case. I just wanted to make sure.
VOPs, Your Honor.
I marked one as a VOP, but not the second, so I just wanted to make sure I was
Your Honor,
right on that.
While he's here, I mean, in full candor, in 12 CF 1017, that case should be closed. Mr. Spears was sentenced to 10 years in prison on the home invasion count and then had probation imposed on other counts. So that's kind of one of the issues with the score sheet. And Ms. Leone is aware of this, so.
Maybe that's why I didn't mark it as a VOP, but don't recall it. You said 1017 was the prison sentence?
The home invasion count. So
1017.
1017, at least on my paper docket, just has one count of home invasion with a firearm. 1016 has 3 other accounts, which I believe went along right with the home invasion count. But we did look into this, and the judgment and sentence on that 1017 count was 120 months in the Department of Corrections, to be followed by probation on other counts.
All right, so the plea and sentencing agreement states Florida State Penitentiary for the home invasion charge 12 CF 1017, followed by 5 years of probation to for all other counts in cases numbered as the following. And it still lists 1017 on there.
That's correct. We'll go ahead and clarify that.
Okay.
I wanted the court to be aware. That's kind of one of the issues with Mr. Spears, and that's what I want to get things cleaned up here. So,
I mean, obviously, I haven't read the judgment and sentence.
Sure.
But we got to make sure the judgment and sentence was written in congruently with what was stated in court. So,
yes, sir.
All right. Thank you. We'll see you back on June 30th. Plea or continue.
Your Honor, this is Calvin Tipton. I know this is an exceedingly old situation with Mr. Tipton. I would like to set 16 CF 1262 for an evidentiary hearing so we can move toward a resolution on both of these cases.
State.
We prefer to go forward on the trial, but I don't think anybody's ready on this particular go, so if there is an evidentiary date available, but we were already looking at that earlier, and looks like it's out there as well.
And in full candor to the court, I'm a big proponent. I've never actually done it, but having an evidentiary hearing in the middle of a jury trial is something that I think is a good use of resources. I'd be okay with.
Do you want next cycle?
I was gonna say, if we want to continue it next cycle and tee it up then for the whole.
If that's acceptable to the court.
What you're saying is just put on the witnesses during the course of the trial, and then I'll make a determination as to the VOP with a separate argument?
Well, pretty much you'd have to excuse the jury so
Of
the
course.
probation officer could testify to certain things, and then the court takes the evidence as the fact finder on the VOP the same time the jury is on the new law.
Have you done that before?
I've never done it. I've never understood why it's not used more often.
Okay.
It's actually very efficient if it's.
I'll certainly consider it. I've never heard of it, so I'm not saying, but you know me, I want to go back and read the rules, make sure there's nothing that I have to look out for, but I don't have an issue with that if you want to set it for, well, it'll end up being the September trial period.
If that's acceptable to the court, we can make that happen.
Yeah, we can do that.
Thank you.
There are several motions that will have to be, and that's why I want to make sure we get everything heard beforehand.
Please.
Okay.
It'll give us time to get all that done.
All right.
Thank you.
All right, 8/27 for pretrial, and we expect it to be a trial in September.
Throwing me. It's like Henderson. Your Honor, this is Giovanni Hernandez and 25 CF 584. This morning I received discovery. I have not had a chance to review it. I would ask the court to leave Mr. Hernandez on for next week, plea or continue, so I can go to the jail and go over the discovery with him, see if there's a way we can resolve this.
June 30th, that's next Monday, Mr. Hernandez, plea or continue. This is the first time up, so.
See you later this week, and I'll have the discovery. Okay, awesome. Appreciate it. Yes, sir. Your Honor, may we approach very briefly?
Sure. Put Mr. Phelan on August back on that date, Mr. Phelan. Mr. Kleins will come out and talk to you again.
Thank you.
Thank you.
Still waiting. Okay, as soon as he gets up here, can we, okay, thanks. That's all I have, Your Honor. I have one more. I guess we just got appointed last week on Mr. Sledge. So as soon as he hits the feet.
I think that was a Nelson inquiry that I'm appointing your office.
I was advised this morning that we've been appointed. So as soon as he gets here, I would ask the court to let me jump in and take him. Thank you.
Michael, this son.
I think so. All right. Mr. Powell, what else do you have? And then I'm going to bring in this Mr. Weed.
Alicia Johnson, Judge. Marty and Mr. Williams left all of a sudden, but I spoke to them. We need to continue the depositions and get them all set up. We're going to set them in Fort Walton because all the witnesses are there and get sufficient time. I'm going to do mine by video. We'll all coordinate together.
Okay. Let's get Ms. Johnson out here to.
We've got a motion for bond being filed, Judge, but we're not going to bring it today. But we're gonna
Say again. I just couldn't hear you.
We're filing a motion for bond for Mr. Johnson. We don't have enough time.
All right, so Ms. Johnson, your attorney's announced that the case needs to be continued so y'all can do your depositions with the co-defendants. It's my understanding, since we talked to you earlier this morning, they've kind of conversed amongst themselves to hopefully get those reset sooner than later.
What about the bond? The motion for the bond? What day is it?
I'm filing it. I got to file it. They won't hear it today.
If you've got a bond motion, you can certainly get that set on an earlier docket. But otherwise, it's going to be 8/27 for the pretrial. Just go ahead and get with the clerk as far as setting that bond motion.
Now, I'll set the motion, Judge.
All right.
I'll come see you. Go get those names.
Thank you, Ms. Johnson.
Thank you,
Anything else,
Judge.
Mr.
That's all I
Powell?
have.
All right, do we have Anderson? On just a second, let me get. All right, is that Mr. Weed on the phone?
Yes, Your Honor, this is Mr. Weed. Can the court hear me?
Yeah, I can hear you. Were you not able to use the Zoom link, or?
I wasn't, Your Honor. I attempted to do so because I was over at the courthouse in Mills Park County, and it wasn't working from my phone, which is why I just called in from my cell phone.
Okay. All right, and what are we doing with Ms. Anderson today? Who's in front of us right now?
We were attempting to try to resolve it, Your Honor, today. I did have some conversations with the prosecutor this morning. He had wanted some additional time because he needed to speak to the victim regarding that. I was wondering if the court may consider a resolution that would be an open plea to the court today, potentially, if I could be heard regarding that. My client is prepared to enter a plea at this time.
An open plea to be sentenced today without you present?
If possible, Your Honor, I'm just trying to expedite it for if the court would consider it at least. She has spent 24 days in Okaloosa County Jail regarding that. She does not have any other prior felony history to speak of. As I indicated to the court, her other felony case was letter of release by the state attorney's office with the alleged same victim, who is her current spouse. And I believe, as the court is aware, going through some significant family law issues, including some injunctions. I did discuss with my client at the jail yesterday the fact that Your Honor was part and parcel and ruled in regards to one of the injunction hearings, which she certainly doesn't have any problem with. But we have gone back and forth quite a bit regarding this. And I was hoping that the court would allow me to consider something that may allow her to be released today, as opposed to it being set off so that the state can speak to the victim.
Your Honor, the state has spoken, that's why I left the courtroom a little bit ago, spoke with the victim. The state's offer in this case now is withhold of adjudication, 2 years probation, no contact with the victim other than what's allowed by social media, other than what's allowed by the injunction, and no making social media posts about the victim.
And can I ask, the state, would you consider a early termination motion at the halfway point if there are no violations of the supervision?
I mean, I'm not going to agree to it now, but I mean, you're allowed to make that motion. But I'm not.
Your Honor, I believe under the circumstances, based upon the discussions I had with my client at the Okaloosa County Jail yesterday, and she did execute a plea form with me there, that we would be inclined to resolve the case today and enter a no contest plea to that offer if the court would allow.
You have the written plea form that you had gone over yesterday? Can I see it?
Your Honor, I gave that written plea form to the prosecutor yesterday. I know when the court had seen me come into the court around noon, that's what I had given him, although I did not specifically put our offer in there. She did sign it, we discussed it. I did put that it was going to be a withhold of adjudication because we weren't certain yet if it was going to be a supervision offer or potentially we were arguing for a time served disposition. But yes, that plea form should be in the state attorney's office hands.
Mr. Sheik, do you have it?
Yes, Your Honor. I have not filled in the terms.
All right.
Based on that.
Ms. Anderson, can you raise your right hand? Do you swear or affirm that any testimony you give here today will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay. You may see the frustration on my face a little bit, and that's really just about having all this kind of moving parts with your attorney not here to explain it to you, because obviously y'all can't have any sort of privileged communication because you're a room full of people, including the prosecutor and the judge in your case. However, first of all, I want to bring up, and it sounds like your attorney, Mr. Weed, has discussed this with you, but as you probably recall, I was the judge in your family law case that happened last year. Do you have any concerns with me making any decisions or handling this case based on the fact that I was on that part of your family law case last year?
No, Your Honor.
Okay. It sounds like if it's an agreed-upon resolution, then I'm not really making any decisions, but I just want to make sure I've asked you that.
Of course, Your Honor. Thank you.
Okay. Please. Let me see what it says, and then we're going to have pass to Ms. Anderson to read. Did you go over the plea form yesterday, Ms. Anderson?
Yes, Your Honor.
So it's really everything but the actual terms.
Yes, Your
the
Honor.
important parts. So I want to make sure it's clear. So I'm going to read it to you, Ms. Anderson, in the way I've been handed in 2025 CF 820. What is the charge? The charge is not listed.
Oh, apologies, Your Honor. It is install, use, tracking devices and apps illegally.
Okay. So I'm going to write that part in because we need a. That's Florida Statute 934.425. And that's a third-degree felony?
Yes, Your Honor.
That's correct, Your Honor.
Your Honor, while you're doing that, I'll print out a score sheet for you.
All right. So, Ms. Anderson, I've got that you be pleading to a violation of Florida Statute 934.425. Installation of the tracking device is a third-degree felony, punishment of up to 5 years and $5,000 fine. Do you understand that?
Yes, Your Honor.
All right. The terms I've been given as far as that were negotiated between the state attorney and your attorney would be to have you plea as charged. It'd be a withhold of adjudication, which means it wouldn't be a conviction on your record, so you wouldn't have a felony conviction for this. 2 years of standard probation, no contact with Carl Anderson, other than that, than the contact that's allowed by the injunction. Is that injunction been modified since I was on board?
No, Your Honor. It's
Okay.
pending a modification.
Okay, so the terms of this would be follow the injunction for any contact issues, since that, if that's changed, we won't have to come back and we can't really change your probation terms at that point.
Yes, sir.
Go ahead, Mr. Weed.
Your Honor, the only other concern I have is, so the court is aware, can we also structure something in there that says, obviously for valid family law court appearances, because I can tell you that they have a mediation coming up I believe in about a week, that obviously they would need to meet with. And so the court is aware. I did stop by her family law attorney's office yesterday after we had gone over this plea based upon my client's request, and to discuss this offer with him as well. And he understands that as they're moving forward with the family law case. And because Ms. Anderson had concerns about that, they have a mediation, I believe, in about 10 days or so. So I just wanted to make sure that that wasn't going to be construed as a violation if we did put pursuant to the injunction or any family law court hearings.
Well, my concern with that is does that potentially open a door to contact or conduct that is different than we're really thinking about here? If I say she can have contact with him at a family law hearing, then she decides to start screaming at him or something like that. I'm not saying you would do that, Miss Anderson, but trust me, I've been in enough family law hearings in my career on the bench that I've seen people get pretty heated against each other during the course of a hearing. So as far as any allowance of contact, it'd be as dictated by the injunction, but you could also attend any family law-related mediations or hearings, but you can't have any direct contact with him pursuant to those.
Yes, Your Honor.
Thank you, Your Honor.
All right. The other condition I didn't get to is no social media posts about Mr. Anderson. I know that was something that I think came up during the course of the injunction case as well. Do you understand that?
Yes, Your Honor.
Okay, and there are times where we used to say, Facebook, Instagram, social media. Just don't post anything about Mr. Anderson or the situation. Frankly, I don't think that's a bad idea in general for anybody in your situation or Mr. Anderson's situation as far as airing these things out. All right, what would court costs be on that, Ms.? All right, $515 in court costs, and the cost of supervision is $40 per month, I believe.
Yes, sir.
I just want to write these things on here and then have Ms. Anderson take a quick look at it. Because although she's signed the agreement, I believe, yes, some of the terms have now been spelled out. So, Steve, if you could bring this over, or someone can bring that over to Ms. Anderson so she can take a look.
Thank you.
Mr. Weed, do you have any concern? Go ahead.
Your Honor, I do not have any concerns after the time that we spent together yesterday as well. I do also want to make a request. My client is a resident of Pasco County, Florida. We would ask that her probation be permitted to be transferred there.
All right, she can be instructed by local probation. She's going to have to meet with them here, and then when she goes back to Pasco, they'll give her the instructions on how exactly to do that. I don't try to get myself in the middle of that. I don't think there's any objection for her to go back to Pasco County, but they've got to do their transfer paperwork. Since it's in state, it shouldn't really be a problem. But Mr. Weed, do you have any other concerns?
Your Honor, this is Mr. Sledge. I talked with Ms. Rivers this morning. We have not received an order appointing our office, but my understanding is that the Public Defender's Office has been relieved. I was just advising Mr. Sledge, hey, I need to continue the case. I did read a police report this morning, but that was the first appearance police report. So other than that's the extent of my knowledge.
I got everything. You want to go right now?
No. I'll have
It's my understanding, I believe I signed the order already, but with everything seemingly stuck in the queue, I can't say that I did. So if y'all can make sure that an order has been signed.
I have seen it, Your Honor.
You've seen it? Okay.
Yes.
Your Honor, just to clarify for Mr. Sledge's benefit, the court did relieve the Public Defender's Office.
Yes, I believe a written motion was filed, and Mr. Sledge, I think you had made some comments at our last hearing, which was the bond hearing, that you didn't want her to represent you anymore.
Do you have that on record? I said I'm ready for trial. What I've been saying for the last 6 months, I ain't on. If that the case, why would she represent me for the bond hearing? You shouldn't have let her represent me for the bond hearing.
It's my understanding, if I recall correctly, after the motion was over, you told her not to come see you anymore.
No, I told her don't come up there until we go to trial. I'm ready for trial. I put in for a speedy trial. As soon as the day I came to jail, I didn't go to first appearance. I supposed to been at speedy trial months ago. It ain't no evidence, ain't no witness, ain't nothing. Y'all done took all my stuff. I got the thing right here. It ain't even no warrant. It's an affidavit that says it does not have. You done changed the charge. The lady dismissed it. She was my attorney when it was dismissed. The state attorney right there, she dismissed it. I got the paperwork right here. It was no action on 12/11, and then y'all trying to bring it back. I don't want that. I want y'all to take the thing off of that. That's why I kept telling you about the bond hearing. It don't need to be now. That's what I'm telling you. This lady is not, that's why I said she don't need to not to be fired, because I want to go to trial with her, so when they go to trial, that way the people know at the District Court of Appeal, because I'm writing them and sending them all my paperwork already. She is my attorney. She know what's going on. She know that this charge was dismissed. I ain't even supposed to be in jail. Ain't nothing. I gave a statement. You ain't supposed to take me to jail for giving a statement. And then I got tased the other day at the county jail. I really need you to look at that. Can we talk about that for a minute? Because I know you can help me with that.
That's nothing to do with me.
You show, because you filed this false paperwork on me. You try to make it look like I've been coming in front of you instead of Judge Gunnar Terry. I got the paperwork right here where you changed it online. Yeah, the summary. You changed, I got both of them.
I changed the summary.
Yeah, you changed the summary from
What did I change, Mr. Sledge?
You want to see? Hold on.
Sure.
I got it right here.
I mean, if you're going to accuse me of committing a crime, I'd like to know what it is.
I'm going to show it to you right here. This is, because already I was charged with premeditated first-degree murder for somebody that wasn't dead. So the police department done lied already right there, so I know I ain't supposed to be in
I think
jail.
we've discussed this before, Mr. Sledge, that there was some
but
sort
you
of
can't charge me with that.
Scrivener's error that was subsequently changed.
It says right here, on 12, right here, it says no action for aggravated battery, use a deadly weapon, possession of a firearm, no action. Judge Gunnar Terry, on 12/11, right here, it says no action. For that one, 12/11, no action. This is the original from Gunnar Terry. Now you come back and you change all the paperwork right here. Like I've been in front of you on 12/3, right here. It say 12/3, Gunnar Terry.
We're not in front of me on 12/3.
Well, it say right here, this is the summary right here. I'm trying to show it to you. I'm gonna show you everything right here, right now in court. You changed it online. It showed the note right here where it was changed, the benchmark. You put the charge back, aggravated battery. You put the felony. It was changed right here. It says from 12/12 to 12/11. You put my name on there for Gunnar Terry for 12/12. You changed it from 12/3 to 12/5 right here. You put the charge back. Come on, take it to him. Go give it to him. You can give it to him.
May I approach you? Sure.
You can give it to him. Not only that, come on. I was charged with premeditated first-degree murder on December 3rd.
Mr. Sledge, one thing at a time, please.
I'm just saying, man. I'm tired of being in jail.
I understand
you
it.
can help me though with the tase part. I ain't mad at the police department no more.
Okay,
I'm tell you.
you understand, I don't investigate issues. That's not my job.
see,
That's not what my role is.
Right.
Mr. Sledge, can I finish my sentence, please?
I'm a bad member, man.
Say again?
I'm showing you right here. Well,
Your attorney has the paperwork you wanted me to
I'm talking about
see.
the probable cause the night I went to jail. It doesn't have no warrant, and it says it does not have any indictment or any filing information. I wasn't even supposed to go to jail. Here, take this up there to him too, please.
Sir, when you're at first appearance, typically an information hasn't been filed because you've just been arrested.
But for premeditated murder, it do. An indictment has to be filed.
And that has already been fixed.
Well, why I'm still charged with premeditated? I ain't got no indictment. Why am I still?
You're charged with attempt.
It says premeditated.
I'm looking at it right now. It says attempt.
Attempt? Why is it still attempt? She got shot in the leg. She just said it at the bond hearing.
Amended information that was filed on January 14th of 2025 says attempted first-degree murder with a firearm.
First-degree murder, December 1st.
Attempted.
I'm telling you what
It's been amended, Mr. Sledge.
But why did you take me to jail for premeditated first-degree murder? You have to give me an indictment for that. Ain't nobody died for somebody that was shot in the leg.
It's been changed.
I need help from Donald Trump, them, and all the black people out here, if y'all listening. Please help me. They trying to kill me. They lying, falsifying charges. If y'all see this on Facebook, come and help me. Send Oprah Winfrey, all the people, because they harassing this black
Mr. Sledge, do you want me to read this, or do you want me to listen to you?
Listen to me. Please listen to me.
You need to just, you've come out here, and I'm going to make sure the record's clear, in a manic, excited way. I've asked you to let me read what your attorney's trying to show me that you've asked him to show me. And the entire time he's trying to explain it to me and give me time to read it, you're talking with the microphone an inch from your face in a way that I can't hear anything but you. So can you please allow me the time to read what you're accusing me of? All right, so let me explain this to you, Mr. Sledge. An initial information was filed as attempted first-degree premeditated murder on December 11th of 2024. You also were charged with tampering with evidence and false imprisonment. Then, for reasons unknown to me, the state filed an amended information on January 8th of 2025, charging you, again, I think this is the error that was made at the time, first-degree premeditated murder with a firearm as opposed to attempt, the same tampering charge, the same false imprisonment charge, but charging you with the aggravated battery in the possession of a firearm by a convicted felon. Then, 6 days later, they filed a second amended information to fix the error with count one, which was the attempted first-degree murder. So as far as your concerns that you think I've changed something, I have not.
You did. It says it right here.
Sir, I just explained it to you. What you're talking about is the clerk's website.
I'm talking about the
Can I
no
finish?
action. You changed the no action from
Can I
another judge.
finish?
Oh, okay. Go ahead then.
When the state filed its initial information, they didn't charge you with those two things. That's what no action means. Then they filed an amended information to include those charges.
Does that mean I was charged with it first? I was arrested for it right here. Here go the arrest paper right here. Aggravated battery, December 1st, right here. You can't tell me I wasn't. I was charged with possession of a firearm, December 1st, right here, man. You trying to tell me I wasn't? The lady dismissed it. Can't tell me I wasn't. There go the paper right there.
Mr. Sledge, who are you speaking to? Because you're kind of staring off into the corner while your lawyer's trying to speak to you.
I'm looking at the man right there because I'm hoping it's the Channel 3 News people, because you can't give nobody a attempt anyway for somebody being shot in the leg and ain't no witnesses.
Again, Mr. Sledge, you seem to be staring off into another corner when you're saying
I'm trying to look at this camera because I need help from the people, the black people of the world, because y'all gonna try to kill me because you falsely, how you gonna say it wasn't? You arrested me for it, but then you gonna say it wasn't? You can't, you changed it online. It's right here.
All right, Mr. Sledge, I've explained this to you. Your lawyers attempted to explain this to you.
I'm gonna go on the bond out. I'll show you. We'll go online. You can't change it. If I was arrested for it and you put it in the computer, that means I was arrested for it. I'll protest. We'll get it right. And then guess what they're gonna say? What no action means is somebody that's not gonna charge you with it. You can't come back and charge me with it, and you already know that. But that's how you try to get my victim to come to court. She ain't no victim. You can't do nothing without her. But I ain't never should have came to jail for murder. You charge me with premeditated first-degree murder. How do you get that wrong?
Who are you speaking to, Mr. Sledge?
Oh man, y'all playing with my life, and you represented me. You took all my kids. You the one that took my kids. We done had it out of court before. I done told you one time. Come on, man. You keep trying to pull this stunt, man. Let the world know what's going on, man.
I'm not sure who you're speaking to, Mr. Sledge. You're staring off into the distance.
You can't say a no action and then say, oh, they didn't charge you. I went to jail for it, so how you didn't charge me with it?
All right, Mr. Sledge, you stated something about me taking your kids.
Didn't you represent my kids? You took my children from me. Tamara?
Well,
You the DCF, you the judge. I remember. In 21. You the judge. I got the paperwork on and everything.
I wasn't the judge here in 2021, sir.
Okay.
That was all done before I was a part of that case.
Okay, I know it. You brought me out here. I come from prison. One thing about you like to hide paperwork. That's why I keep showing that you changed the stuff online. You can't say, oh, they didn't charge you with it. You took me to jail for it. So how you didn't charge me with it? I was arrested and put in handcuffs for aggravated battery. You can't.
Again, Mr. Sledge, for at least the fifth time, I'm pointing, when you're talking, you're looking
at
nobody in particular. Are you addressing the court?
I'm addressing the world. I need the world to understand what's going on, that you're trying to kill me. I'm a black man, and you're falsifying evidence in the charge with the police department. They charged me for first-degree premeditated murder. There's no reason to take me to jail. Y'all done took all my clothes. You stripped me butt naked when you didn't have no warrants. I got all the documents. There's no warrant.
What date are you asking for, Mr. Kleins?
You got me in jail.
All right, August 27th. Thank you, Mr. Sledge.
I need help from the black people. Y'all help me.
I'll come see you at the jail.
Mr. Sledge, I'd appreciate it if you could have a calmer tone next time you come in.
That's all I have, Your Honor, if I may be excused.
All right.
May I approach briefly?
Yes. Do you need state with you?
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Take about a 15-minute recess and then we'll get back to it. said the pro se people. Hi, Ms. Brumbaugh. Did y'all figure everything out?
Lisa?
Is that all of her conditions? Okay.
That's what I was told I was violated for.
I'm showing the only issue that came up on the affidavit of violation of probation, this is why you were given a notice to appear as opposed to a warrant, was that it was costs. So it says, failing to make court cost payments to probation officer as directed in accordance with the payment instructions of the court. Officer states that offender is $727.69 in arrears as of June 3rd.
Been paid since June 4th.
I'll have any. All right, can I see the receipt? Is correct pay what takes all the payments now?
Yeah, they changed
Okay,
it.
it used to be a different name. I just
Yeah, it
didn't-
used to be JPay. They
yeah,
changed it.
That's what I remember.
That's why it took me so long, because I didn't know it.
All right, so I'm showing that a payment of $774.25 was made on June 4th, so that's the day after the affidavit. Anyone else? Sounds like everything's been paid then.
Then the state is good at dismissing the violation and considering for probation.
All right. VOP is dismissed. Hold on. Probation's terminated. I want to make sure it's said and that you hear it, so you know that you're done.
So I, my paperwork says I'm
Well,
still on until like the 2nd.
July 2nd, I think.
Yes,
Yeah, so you're still technically on until July
Okay.
2nd.
I just want to make sure.
All right, perfect.
All right, thank you.
Thank you. Well, he's represented by Williams, but Howard is not. There's the- Yes. Mr. Williams.
Judge, I've got a plea offer on Mr. Moss that will resolve both. I received that this morning, so I just need him brought in a little conference room for a few
Okay.
minutes. He's one of the,
So why don't you go talk to him and I'll handle the other ones.
I'll need him and Colton Keaton. Yeah, Keaton. And, I will. They'll forget. Basically, I've had a few changes in the offers this morning.
All right, sounds good. Good afternoon, Mr. McDonald.
Hey.
How are you?
All right, how you doing, Your Honor?
Good. Well, I know you filed quite a few things, but what I want to address first is that you asked for counsel.
I did ask for appointment of standby counsel, Your Honor, I did.
Okay. But my concern is when you stated that you want standby counsel, but then you put in there what you want them to do, which is counsel things. So standby counsel is someone who's there to take over the case, not for someone to basically, kind of just do some things that you want while you represent yourself.
Yes.
So do you want counsel appointed, or do you want standby counsel that can take over the case at some point in the future? I just want to make sure I'm clear.
Yeah, I'd like to have standby counsel that may be able to take over the case in the future, Your Honor.
All right, and is there a reason why you don't, I mean, we've gone through the Ferretta issue before. I've asked you all those questions, and based on recent case law, I don't want to belabor those issues. But do you still feel that you don't want counsel to represent you to do all the things that you're asking to be done?
Not at this moment, no, sir.
Okay. Just trying to look at your cases to see if you've had someone appointed to you in the past. I just don't recall at this point. You recall, you had a public defender before, right?
Yeah, it's Mr. Williams.
It was Mr. Williams?
Yes.
Russell, I'm not sure. What I'm trying to figure out is to make sure there was never any sort of conflict where y'all got off and someone else may have been appointed, or just at that time he went pro se, because I don't want to appoint y'all to find out that you can't talk to him anyway.
My recollection, Judge, is that we represented him, and that at some point he decided he wanted to represent himself.
Okay.
I think.
Any issues with me appointing y'all as standby counsel?
No, and I just want to put on the record for Mr. McDonald's benefit, he needs to understand, standby counsel, we're not his secretary, we're not his legal assistant, and we're not co-counsel. We either represent him or we don't, and if we're standby counsel, that means we're standing by.
Okay. Do you understand that, Mr. McDonald?
Yes, sir, I do.
Do you want to have a discussion with him in private to see if y'all can
I
talk?
would like to have a discussion with him.
Okay. Would it be you, Mr. Russell?
Go back to Mr. Williams.
Okay.
I'll be happy to meet with him in the back and chit-chat with him.
Just to make sure you understand what that process is. Mr. McDonald, up here, please. Just so you understand how that works, and that, like, the thought I had in my head when I saw the standby counsel request is, they're not your paralegal just to go do some work for you while you still represent yourself.
Well, Your Honor, the thing is there's an unfair balance of resources here. As you know, I am incarcerated, and so that's what it's about. It's not the effect that that I can't produce competent work. I'm not required to do that in a technical sense. I'm just a pro se litigant. But there's some things that it is above me right at this moment that incarceration creates that barrier.
Okay.
And I need to have some understanding with that.
All right. Well, I understand that too, but see, that's the point. As I've stated and Mr. Russell has stated, they're not just going to do what you want when you want it, and then you say, I'll take it from here, and then you call them up the next week and say, now I need you to do some other things for me.
No, I can't call him.
Well, send them letters, whatever it may be. But what I'd like...
I'd like to talk to Mr. Russell, please.
I'm going to let you talk to Mr. Russell, then we'll call you back up. And then depending on what y'all decide on how you want to do things, we'll talk about how we're going to go forward. Because, Mr. McDonald, you filed a lot of things, and sometimes they're in the wrong file, or they're supposed to be in several files. I want to make sure you understand this, because I've explained it to a lot of even lawyers today and yesterday. There's a kind of a log jam in the clerk's office right now with their change in some software. So a lot of things aren't being processed as fast. Typically, they're getting emailed to me, so I've reviewed everything that you've sent, but it doesn't show up on the docket right away, so not everyone else can see it. So I just want to make sure you know about that too, because it's causing a little bit of delay with most cases.
I see that. I've seen the effect of that.
Okay, so it's just been the past couple of weeks, but I'm going to send you back, talk to Mr. Russell, and then we'll call you back up once y'all are ready.
Yes, sir. Thank you, Your Honor.
All right, thank you, Mr. McDonald.
Is there a room open? Okay, I'll go talk to him in this room.
All right, who else do we have on the pro se part? And Mr. Powell, we'll get to you after that. Mr. Pruitt. All right, Mr. Pruitt is here on an out-of-state fugitive. Do you have other cases, Mr. Pruitt?
Yeah, I think there's three cases on the south.
Okay, that's what I'm just trying to figure out. So the only reason you're in front of me is because of this. You've got an out-of-state warrant. And so basically, a case gets opened until you get transferred to wherever you're supposed to go. There's not a whole lot for us to do, other than once you get transported, we'll close the case out. But it looks like you've got several cases. You've got one, two, well, you've got two cases in front of Judge Stone on July 14th, and it looks like you have, let me see what happened with these others. Transferred. Okay, that's it. I just wanted to make sure because there were some other misdemeanor county court cases that were listed, but those have all been consolidated or transferred into the felony cases. All right, so there's not really anything to do for this part. Let me just take a look real quick. I just don't want to ask you questions about some of these things because I don't want you to say anything that could be detrimental to you. So, Mr. Pruitt. All right, so you've got something out of Kentucky, it looks like. All right. So once you resolve all your cases here, then Kentucky will come get you, and this case will be closed.
Yes, sir.
Okay. Any questions about that? Do you have a lawyer on your other cases?
I got two public defenders.
Okay.
I think Mr. Nopes, I know, was on at least one of them.
Yeah, I'm seeing Mr. Nopes on one, and then it looked like Thomas Koch on the other one. So, and that's just because of the conflict issues, but they may look at it and find out they've got a conflict on the other case, and it might be sent over, because I know there's some co-defendants involved. I don't want you to say anything about that, but that's my understanding. And y'all kind of have the same issues with Kentucky as well. So there's nothing really to do for our case. We'll put it on our August 27th date just for kind of control of the case, just to make sure that it's ultimately closed when it needs to be. But July 14th is going to be your next court date in the south end of the county with Judge Stone. All right. Thank you, Mr. Pruitt. Are you Mr. Rudolph?
Yes, sir.
All right, Mr. Rudolph, you're here in 25 CF 754. Mr. Sheik?
Your Honor, this is a case that's being transferred to the south end.
Okay.
I have it looked into, appears it's in the process. I'm not sure where it is at that, but I have the request in, Your Honor.
Let me just take a quick look at your other case. All right, so what that means, Mr. Rudolph, is you also have 2025 CF 293 in front of Judge Stone in the south end.
Yes, sir.
What typically happens is the newer case gets transferred to where the older case is, so that way you don't have court dates in front of two judges at this, in two different courthouses.
Yes, sir.
All right, so you've got 293, and Ms. Dudley represents you on that one.
Yes, sir.
Okay, is she going to represent you on this one too?
I just haven't had a chance to contact her.
Okay, because just if you ultimately can't hire her or can't afford to hire her for the new case, you can certainly apply for the public defender, and one can be appointed to you in the other case. But in the meantime, we're going to transfer you over to the other division, and then you've got court there on July 14th in front of Judge Stone with Ms. Dudley. And if you could make sure, Mr. Sheik, that if y'all haven't got me in order, I haven't seen one yet, but make sure I get that so they can put them together. Otherwise, I'm going to make a control date of August 27th just to make sure that everything gets done. Because if we don't give you a court date, it may just kind of disappear.
Yes,
So, but it looks like everything will be in front of Judge Stone going forward. All right, thank you, Mr. Rudolph.
Charles Russell Public Defender's Office. Judge, this is Camden Barnum. Case number is 22 CF 3192. Can I have just a moment, Judge?
Yes, sir.
Judge, on Mr. Barnum's case, Ms. Farkas is sick, that's why she's not here today. But she is working on.
Recently been appointed to it?
She took
Or
over.
took it over?
She's with the PD's office, so she's going to handle the case. She wanted to come today, but she's sick. She asked me to ask the court for a continuance to the next pretrial conference, 8/27 at 9.
I understand. I mean, Mr. Barnum's case has been pending for quite some time. I know Ms. Farkas has just been assigned to it, but realistically, when are we going to be able to get this case to a resolution, and whether something gets worked out or there's a trial?
And Ms. Glisson might be able to address that better than I, because I'm only kind of.
Ms. Glisson, can I get you to come up to the podium? You're just way far away from that microphone. Oh, no, just to the podium. Sorry.
Your Honor,
I just don't want you to have to shout and still not get on the record.
as soon as defense counsel's ready, the state can be ready.
Okay. All right. So, Mr. Barnum, have they discussed that with you, court dates? Do you know that Ms. Farkas has been assigned to your case now?
Not yet, Judge.
She's come to see you.
Yeah, she's come to see me.
Okay.
But we still haven't discussed a timeline or anything yet.
No, I said, but you know that she's on your case
yeah.
now?
Yeah,
Okay,
yeah.
I'm just making sure of that. All right. So, obviously, this case has been pending for 2.5 years. I'd like for it to get close to a resolution at some point, because, you have a right to a trial, and, there's a speedy trial, but y'all have asked for several continuances. But I was just hoping there was some idea on when it could be ready to go, because I know you've had several lawyers over the recent 6 months. I think this is at least your third. And
Judge, if you wanted to pass it to docket day, I can see if she's available that day so that she can come and address the court.
Well, I don't expect it's going to be put on the trial docket this time around.
Right.
But I would just like to know if she's had a chance to look at it, to determine what she thinks might need to be done. I'm not going to ask strategic questions, obviously, but are there more depositions that need to be done? Are there other motions that need to be filed? Just so we have an idea on when we can get this thing to a resolution.
Status then?
She's available. Ms. Glisson, are you going to be here?
Not, Your Honor.
Okay.
Or I can ask her to coordinate a status hearing date with everybody's calendar?
If that can be done, again, it's not urgent. I would just like to, I feel those are the kind of dates that get things moving. But, so what we'll do, Mr. Barnum, is we'll put you on August 27th, which is your next pretrial. But if we can coordinate something, especially if there's anything that the court needs to be be aware of or make any decisions on, I'd like to get them going too. So if there's any pending motions, I don't even know at this point if there are any pending motions or any that are going to be filed, but let's just try to expedite it.
I'll let her know, Judge.
Okay.
Sure.
All right.
But 8/27 for now.
Yes. Anything else, Mr. Barnum? No. Okay. We'll see you next time. Okay. Do we have the attorneys?
Mr. Price?
It's me.
That
Good afternoon, Your Honor. This is Jacob Price before the court on 19 CF 3106. I'm still doing work with an expert, so we're not ready to go at this time. I have spoken with Ms. Glisson. We've talked about the different murder cases that we have and tentative dates, for the cases. We don't expect this case to go this year. We do expect it towards the beginning of next year.
And this is one of those cases, Your Honor, it does have an old date on it, but he was just found competent.
Sure. That was just.
Of last year, December of last year.
Okay, I thought it was even more recent than that.
I believe it was like.
It was probably right before I took it over then.
We had to get 3
There it is.
evaluations.
It was 12.5 of 24. All right, do you understand that, Mr. Price?
Yes, sir.
All right, we'll put it on August 27th. Obviously, if you don't need that date, we can talk about moving it by written motion. But I'd like to see kind of where we're at going forward, because again, it is a pretty old case, but it's only been really back on the docket for 6 months. All right, thank you,
Then
Mr.
we'll be
Price.
back out to talk to you, okay?
Okay, thank you.
If I may have just a moment, Your Honor, with Mr. Washington.
Yes.
Your Honor, this is Amos Washington before the court on 21 CF 2143. We're in negotiations with the state. We're trying to see if we can resolve this. If not, we were looking at a trial date later in this year. We still have a couple of issues left to resolve. And as I had mentioned last time, we had retained an expert on one of those issues. He unfortunately was not able to come to the sheriff's office on the days that he had planned because he ended up with COVID. So, but this case is actively being worked, and we are in the midst of negotiations, and we're hoping to try to resolve this case.
Is that the phone downloads?
That's correct,
For the
Your Honor.
expert? Okay. All right, Ms. Glisson, state's position?
No objection, Your Honor. I think if the negotiations fall through, we're going to aim for the November trial period to try this case.
All right, you understand that, Mr. Washington? Okay. And we're going to see you back on August 27th. Talk about setting your case for trial sometime before the end of the year. Thank you.
I'll be out to see you.
Sometime
okay?
before the end of the year.
Mhm. Oh, yeah.
That would be good.
Oh, yeah.
Yeah, we've got those trial weeks. Ooh. One of my November trial weeks is only a 4-day week because of Veterans Day.
Okay.
And that looks like November 10th is that Monday, so I'm guessing Tuesday then is Veterans Day, and then, so it's going to be a weird week to try a case. Just putting it on everyone's radar for purposes of setting things,
And I feel like Mr. Washington's case probably could be tried in 4 days.
including jury selection?
I think so.
Okay. My concern if it's 4 days,
And then it's
you don't really want to start on a Monday, take Tuesday off, and go Wednesday. So, all right, we'll figure it out. South.
Your Honor, this is Richard South. He's before the court on 23 CF 1796. As you know, we had made a public records request for the FDLE expert notes back in, I think it was October of last year. Nothing happened. Then earlier this year, this court signed an order that FDLE agreed they'd be okay with regarding production of that material. That has not happened. We have reached out to them, and the response was basically that it's public records and you'll get it when you get it. And I have come across a couple of things since then, and if I was going to show Miss Leon, she'd asked me to present her with it.
They're calling it public records even though there's a court order that says turn it over.
That's correct, Your Honor.
All right, I'll entertain your motion to compel whenever you file it.
Okay, thank you, Your Honor, because there is a judge in Escambia who has done something similar and gave them 30 days to comply, saying that it was a legal proceeding and therefore we were entitled to that information. So, thank you, Your Honor.
Yeah, I think the constitutional rights of citizens are more important than the delay in bureaucracy.
So I will be filing the motion to compel, Your Honor, and we will be setting it as soon as possible.
And it's certainly not being critical, but I understand that sometimes that's an order, usually the court orders enough, but apparently it's not, so they're going to have to get another one.
If I may inquire, Your Honor, Ms. Rivers, could you forward to me any correspondence that you've had from FDLE in response to your request, so that I can even address it with them?
The lady, that the female attorney who handled it before, she was no longer handling them, and she had sent me an email saying, I'm referring you to somebody else, and it was a male attorney, and that was their response.
So you're saying it's a lawyer for FDLE that said you'll get it when you get it?
He said it's public records. It's in the queue. It's public records.
Also, they meant that they have to get to it, but it's not, they're not refusing to share it. Is that?
They're saying it's public records. It's in the public records request queue. We're given no idea, the gentleman will give us no idea of when we could expect it.
I understand.
They said if it.
Did you have an order that you said from Escambia?
I haven't, yes, Your Honor.
I'd just like to see it.
I made a copy for you in the state.
I thought you handed her one, but I didn't get mine.
I've written on both of them, is that okay?
Is Miss Leone's written on? I'm sorry? Is Miss Leone's written on? Okay.
Motion to compel.
Oh, I see.
I just want to see which case it was and.
I'm trying to read it too.
They did indicate that if there is a trial date, that they would try to get it before trial. I gave a date of the next trial cycle, but I haven't heard any response to that.
They want you to set it for trial without the evidence that you're looking for, and then they'll turn it over to you so you can try to figure out if you can still go to trial. What would you like to do today, Ms. Rivers?
Your Honor, I'd like to continue it, and then I will file a motion to compel.
I don't have any say in Your Honor.
I
Whatever.
just, obviously, if you get it all worked out, let's figure out this part. But I'd like to have the motion heard sooner than later.
Not only this, I wasn't made aware of the status until this morning, so as she reached out to me earlier, maybe I would have had an answer for us today, but I haven't. Like, what I'm saying is, I don't know if hopefully I can resolve it short of having to have a hearing on the motion to compel. And if, Ms. Rivers, if you can forward to me, please, the contact information of the FDLE representative who you've been in contact with, I'll reach out.
I mean, but they agreed to this language, right?
Yes, Your Honor, this was the language that they sent us and said, insert your portion here. This is what we agreed to.
I don't have it in front of me. The order that Judge Oberliesen signed, did it have a deadline on it?
I'm looking at it right now.
No,
It doesn't
because
seem to have one.
no,
That's what I'm reading right now.
It doesn't.
Okay, I was wondering.
And again, I submitted what they sent.
I get it, I understand.
I signed it almost 3 months ago.
That's correct. We were here last cycle waiting for it still.
In fact, like, I'm looking at it, I signed it by hand, because you handed it to me in court because it was agreed upon, and I wanted to make sure it got filed as quickly as possible, so I didn't put it through the system. I just signed it and handed it to the clerk. All right. You understand that, Mr. South? That she's trying to get it there?
Yeah, I've been here for 2 years, and
He's ready to go to trial.
Because I am innocent. This did not happen.
I understand
That's all
that,
I'm
but,
It didn't happen.
you know, I just want your lawyer to be prepared with what they need, and.
She's doing her job.
Yep.
I'm lucky to have her.
Okay.
Appreciate it.
But I just want to make sure it gets done. That's why,
Yes,
I
sir.
mean, you heard my first response was, well, then file the motion, and I'll send them another order that says we need it a little faster than whenever you get around to it.
Please.
Be back out to see you.
All right, thank you, Mr. South.
Judge, this is Mr. Moss. We've got, or we've been talking about a arrangement to resolve this case as well as the Howard extradition matter. In talking with Mr. Moss a few minutes ago, though, he's asked that I talk with the state a little bit more about something. And so if we can set him for Monday for plea or continuance, I think we're going to be able to get all of that resolved.
State have any issues with that?
No issues, Your Honor.
All right, so Mr. Moss, we'll see you back on next Monday, June 30th at 9 o'clock for a plea or continuance.
Thank you, Your Honor.
All right, thank you, sir. All right, this is Robert McDonald is back after having talked to Mr. Russell. What have we figured out?
At this time, I'm going to continue to just represent myself, Your Honor, because I was under a different impression by standby counsel being appointed.
Well, then, what I think I'd like to discuss with you then is, how do you want to go about doing the things that you're requesting?
I thought we had said the last time that we were here, I gave you some names to do the depositions.
I understand that, but then you asked to have counsel, and so I have to make sure I'm doing what you want.
I don't want.
You don't want counsel, no?
No.
All right. How do you suggest we handle depositions when you're in the jail?
Well, there is a conference room at the jail, or we can transport here to the county courthouse and do depositions.
Okay.
The state would prefer the courthouse because taking lay witnesses and people to the jail may not be appropriate.
Okay. Ms. Leone, can you help coordinate that as far as the courthouse? I think if you probably talked to Ms. Hall and court admin, she could probably help set up the room, or maybe Ellen Hyde.
And yes, Your Honor, and because obviously he's in the jail and he doesn't even have an email address that I can copy him on the correspondence, how do you suggest I do that?
I think you can mail it to him.
No, I know, but for example, by the time he gets a mail in the mail and some communication may need to occur prior to the delivery of the mail. And what I mean, for example, is securing a court reporter if he's going to need one. That's another issue about how to do that. Because they are his depositions, so unless he has a way to record them, or I don't know. And I've never been in this situation before, honestly. The last time, I can tell the court that we had a defendant, pro se, was appointed Mr. Gibbs as standby counsel only to the extent of facilitating, sharing the video evidence and.
But that's what I brought up.
I understand, but
And
it
Mr. Russell
doesn't
from the
work
Public
out.
Defender's Office brought up, that's not really the role of standby counsel, is to be a paralegal or a legal assistant or even investigator for a pro se defendant.
I agree, Your Honor. I'm just saying what happened for another case.
I appreciate that, Ms. Leone, but I think we have to stick with what we've talked about.
And the other big issue that I'm having, Your Honor, is that I need to share video evidence with him, right? He needs to provide me, like for instance, like Mr. Riosti earlier in the other case, he provided me with this thumb drive, the external drive, and I'm going to copy it and give it back to him. It shouldn't be, the state is not going to provide those flash drives to the defendant for free, so he would have to provide them to us.
But also, you don't have anything to play them on, right?
No, that I was told by the jail that they can let him use a special laptop and allow him to watch it. I just.
Does that sound right, Mr. McDonald?
They do allow that.
Okay. Again, this is not something that happens very often, so that's why I'm asking, and I don't want to assume, the last time we did it 2 years ago, this is how it worked. Well, things change, and I don't want to set it up where we can't fix it if it's not working.
Yes, sir.
Okay. So why don't we do this? Why don't we have you come back on Monday?
Sure.
At that time, if you could, Ms. Leone, find some dates that you're available for the deposition.
Yes.
What particular witnesses or cases do you want again, Ms.? I've written it down before, but I'd rather just write it down again if you could.
Well, since there's multiple cases, Your Honor, can I submit that back?
Well, I'm just worried that by the time we get it, because, I've explained to you, by the time you mail it, you're mailing it down the street, but it still takes a couple of days to get there, and then they have to process it, and then we have to make sure we get it.
Could he bring the list on Monday?
Yes.
Why don't you do that then?
Yes.
If you could just write down a list of each case and each witness that you need, and then if you could find a date that we could put those on, Ms. Leone, what I'll do is try to reach out, have my office reach out to the jail and court administration as far as scheduling and how we can get a room that works. Because obviously, Mr. McDonald, you're going to have, some sort of security or corrections officer with you at all times while you're in the courthouse for that purpose.
Yes.
All right.
Monday?
Is there anything else that you want to address, Mr. McDonald? Because you filed a lot of things, and when we've come in, I've asked, what do you want to address? And do we want to...
There is one issue. The email that I sent Ms. Leone was, she said that I went outside the rules of discovery. I don't have the availability to submit hard copies of mail.
Sent
I don't
an
get
email?
hard copy mail. I get digital mail, and there's no way, once it's mailed to me, I can't produce it to the court
I don't
in
know.
that same form. There's some emails and based on my alibi witness and pertaining to my whereabouts of the date of the offense, the alleged offense. Which made it physically impossible for me to do it. And I was in touch with an investigator with the sheriff's officers. So, and the phone number will coordinate with, will be in the same to his number. So I was.
Can you have the people send it directly to her office?
And I sent it to you too.
Well, you shouldn't send me evidence.
I didn't know how to do it though.
Well, I'm telling you, I'm not supposed to review evidence outside of an evidentiary hearing or a trial.
But my family did it, and that's who I'm using that's the only people I have because I am in that barrier of resources.
Okay, well, you've chosen that, Mr. McDonald.
My family. And Mrs. Leone sent an email back saying that she confirmed having the statement and the text messages and the statement from the alibi witness.
What you have to do is do a discovery exhibit and list what those things are that were sent.
All right, I can do that.
I just vaguely remember, is that with Miss Rebecca Feller you're talking about?
Yes.
Okay, she's
I
not
remember
even a party to the case, I'm not.
Well, she's not a party, she's
an alibi witness.
She's an alibi witness, he says, but is she a family member?
No, she's not.
Okay. But she's not providing evidence to the state, right? Just, she's a witness of yours.
She's a witness to where my whereabouts were. On December the 18th.
Well, who are you trying to depose witnesses that the state has listed?
Trying to depose witnesses.
That's not an answer. The question is, are you trying to depose people who've been listed by the state attorney as witnesses?
Yes.
Who's that?
The officers that are involved.
Okay, but are you expecting to depose witnesses that you're providing?
No.
Okay, I just want to make sure. Trust me, I think I've had lawyers try to depose witnesses that aren't listed in a state's discovery exhibit. Like they want to depose their own witnesses. I've seen it happen before. That's why I asked the question. It's kind of like the warning label on things. They wouldn't put it on there if someone didn't do that before. So I only asked the question because I've seen it done improperly, and I wanted to make sure because you are pro se that we have everything that we need for you.
Yes, sir.
Well, actually, Your Honor, he did list some people who were not my witnesses, and he asked for them to be subpoenaed by the court.
Yeah.
For what purpose?
For the hearing date, when I had filed the motion for dismissal.
Okay.
Based on the evidence.
Okay, but you understand, motions, you have to look at the motions for dismiss, start with, I'm not giving you help, but 3.190, take a look at that. A motion to dismiss is not for me to look at the evidence and then make a decision as to whether or not you did it. That's what trials are for. The motions to dismiss are basically, you have to sign off on an affidavit that says, these are the facts.
I submitted the affidavit with it.
So you filed it under a C4 motion?
Yes, I did.
Okay, do you want to set it for hearing? Have you looked at it, Ms. Leone? Have you traversed or demurred it? It hasn't been set for hearing, so I'm guessing you didn't, but.
No, Your Honor, I don't think it raises to legal sufficiency for me to even provide a response. That's why I didn't.
Okay.
Also
Has there been a
because he
motion
lists some witnesses that I never heard of, and and obviously, if he's in a motion to dismiss, if he's bringing in more evidence, that means he's disputing the evidence.
Sure.
That's
So,
what I mean.
Again,
Bringing any new evidence, it's based on the same evidence as has been.
no, but basically a motion to dismiss is that the facts are undisputed
They are undisputed.
by you, but if the state disagrees.
But she didn't even look at it.
Can I finish, Mr. McDonald? I don't want to go through this with you again, where you just want to argue with me. I'm trying to explain things because frankly, you're representing yourself, but a lot of the things that you're doing aren't right. And I'm not trying to give you advice, but I also have to make sure you're doing things that are legally sufficient or not. A C4 motion is not about arguing what the evidence is or isn't. It has to be stipulated or undisputed, because then the state can just file and say, we don't agree with the facts and evidence that you put on your motion. And then that's what we call a traverse. And then it gets dismissed. I'm sorry, rephrase that. The motion gets denied based on that. But if it's an issue about you think the evidence tends to show that you're not guilty, then that's what trials are for. But you want to do discovery before that, right?
I want to do depositions, yes.
Of the state's witnesses.
Yes.
And only the state's witnesses. And then the state can decide if it wants to depose any of your witnesses.
That's right.
Yes, Your Honor.
Okay, so what we'll do is on Monday, June 30th, we'll come back. Mr. McDonald, you'll have a list of each case, each witness that you want to depose. And then Ms. Leone's going to have a date so we can try to set those up with a deposition in the courthouse. But again, I just got to make sure that, the courthouse, court administration is ready for that, court security is ready for that, the jail's ready for transport, to make sure all that stuff is being done.
Yes, sir.
All right.
Yes,
Anything
sir.
else, Mr. McDonald?
No.
Well, we'll see you in 6 days, so if there's anything else, please bring it up at that time.
And one last thing, Mr. McDonald, do you believe your family members can bring a flash drive so that I can give you the video evidence?
Yes.
Okay, good.
Okay. I'm guessing they can just drop those off at your office, Ms. Leone?
They can do that if they want, yes, in any way.
All right, thank you, Mr. McDonald. Oh, can we take Mr. Powell real quick? Yeah, go ahead. I don't think he's got an inmate.
No. And Judge, thank you for accommodating me. This is
So I think what we're talking about is the Busby from yesterday?
Yes, sir. It's Justin Busby.
And just to kind of sum up what the issue was, is last time that we were here in April, I said that was going to be the last continuance. And yesterday, Gil Powell came in and said that y'all needed more time and wouldn't be able to try it till next cycle. And frankly, I needed to know why, because this is an 18-month-old case, if not more, at this point.
And Judge,
Closer to 20 months now, because that was 18 months ago before. And I know there's the issues with Mississippi, but I need to know what needs to be done and why it can't be tried now.
Of course. So Judge, just for kind of background purposes, we've had several rounds of depositions. The last round in Mississippi was April 3rd. We had a round on April 9th. Those had to be canceled. The state was in docket day that day, and we reset those. We did those on June 4th. And we've got our last round coordinated for July 21st. The round of depositions in Mississippi, the main detective either was served and didn't appear or was not served. I'm not 100% sure on that, but I believe he left the police department. So our final round of depositions is July 21st, where we're taking the main investigator from Mississippi. Mr. Busby is also getting a risk assessment, and the state and I have been in plea negotiations for quite some time. There's been a kind of back and forth, a couple of different offers, but we do need to finish the last round of depositions.
Is that just the officer from Mississippi? Or is there more?
There's a few other witnesses that are family members that, of the victim that we're going to list that didn't appear last time. So some of the Mississippi witnesses moved to Michigan and did not get served, and so it's just been a big kind of a mess of where is everybody.
Are those people listed in discovery from you?
Yes, they are. And so kind of there's two separate cases, one in Florida, one in Mississippi, involving, I guess, 2 or 3 different incidents. But, you know, we do need to take the main investigator's deposition. He wasn't served the last round. There's 2 other attorneys in Mississippi on this case, so coordinating it and tracking down all the witnesses has been kind of a headache. But we do have a date, and like I said, I anticipate plea or trial.
So are y'all going to Michigan for depositions now?
Well, the attorney that's representing those family members said they would make them available last time, whether by Zoom or over the phone. So I don't anticipate going to Michigan.
Ms. Basso, and sorry, your reaction to a couple of those things. So what's the state's position?
The state has been available. One time I did have to continue it. I was in trial with Ms. Berrickman. But other than that, we've been available for depositions from the beginning of this case.
I wasn't saying you weren't.
Well, you said they were continued for...
One round we had to cancel, yeah.
Okay. Is that accurate?
One was because there was a trial.
Okay.
That's correct. I
That's
was in
fine.
trial with Ms. Berrickman. Your Honor, we have no objection to doing these by Zoom. As far as we're concerned, the only essential witness would possibly be the case agent. Everything he did was pretty much on body cam as well. So we understand that the defense wants to do his deposition, but this keeps getting dragged out. It's maybe not Mr. Powell's fault that Mississippi won't cooperate and weigh in and get some dates for us. But that's...
I guess my question is, this case officer's in Mississippi, right?
The main investigator, yes.
Okay. What is he being served with for a Florida case? Have y'all sought an out-of-state subpoena?
Well, that issue did come up last time. We did kind of work around that. This Mississippi prosecutor was making them available to us, so it was kind of...
I guess my concern is that didn't seemingly happen.
Right.
So,
well, all the other witnesses did appear except for that one. I just don't know if he was served or not served.
I think there was a question yesterday, and again, you weren't here for this.
And I apologize.
But that's fine. This is why I'm kind of giving the recap of it, is that he basically said he hadn't been served, which was why he wasn't showing up, because he hadn't been served with a subpoena. And I could be wrong about that, but I think that's what was said yesterday.
He hadn't been served properly, Your Honor, and he was no longer with law enforcement.
But my concern is the Mississippi prosecutor going to be able to get him there or not? Or are we just going to be talking about this again next time?
Well, that's a valid concern.
Okay.
But
is he being subpoenaed in the Mississippi case too?
Your Honor, Mississippi doesn't generally do depositions, so the Mississippi prosecutor was only there as a courtesy when we actually did this.
Okay.
That wasn't her show, that was mine. And the defense had the responsibility of getting the witnesses there. We actually ended up
And
calling some of them to make sure they would come.
the state did help us get them there, yeah.
Okay.
And
I guess my concern is if we come back in a couple of months, if I grant a continuance, and the story I hear is, well, we were told he was going to show up, and he didn't show up. I mean, my first question is going to be, did you seek an out-of-state subpoena
right.
to be enforced by a Mississippi court? And if the answer is no, it's going to be, okay, which trial week would you like in this cycle? Because I'm not going to keep doing this, Mr. I understand you've tried to do it the easier way, but if it's not working, then we got to do it the right way.
And my belief is that nobody's pushing back on the out-of-state subpoena. I just don't know off the top of my head the issue for the last time, but the other law enforcement officers were available and they did appear, and I believe we even tried to reach him at that time, but
I think what I heard yesterday was he's no longer with law enforcement, so therefore he maybe doesn't feel he has to show up because he gets asked nicely. And that's my concern. I just want that to make sure it happens.
And that's something I'll talk with Ms. Carter about, if we need to just go ahead and do an out-of-state subpoena, just to, so you don't tell me which week.
I'm not trying to be difficult, Mr. Powell, but I mean, when cases are pushing 2 years old and we were kind of butting our heads against the same problem every cycle, I'd like to get it resolved. So
understood. And Judge, I mean, like I said, I fully anticipate we'll be back here either ready for trial or with a plea.
Okay. Ms. Basso, anything else from the state?
And if not, then Ms. Carter can come to court.
I'm going to need somebody, because that was part of my concern yesterday is you weren't here, and Ms. Carter, who I've never met, wasn't here, and a lot of it's kind of third hand, what happened, and that's why I wanted to come directly from one of you so I understand what's going on. I tried to set it for Monday. It's my understanding you're going to be out of town, so that's why I wanted to. I'm willing to talk about it. I need you here.
Thank you for accommodating me today,
no
Judge.
problem.
And I was kind of bouncing around all between a bunch of different documents Monday.
I know the routine, Mr. Powell.
Mr. Powell indicated earlier in error, I believe, July 21st, July 23rd, sir.
July 23rd. Thank you. July 23rd.
Have subpoenas been put out for anybody, or do we have a notice that shows the right day? I think we had that issue in a different case yesterday where someone had given notice for one day. I think it was not in your head. I think it was Mr. Cobb, and they had the wrong date, and therefore they had to cancel everything because they had the wrong dates.
We will have the right date. I will have the right date. And we did finalize these roughly today, but we've been back and forth on some dates.
Okay. So it's July 23rd?
Yes, sir.
Okay.
And we're looking at 1 p.m., just to confirm, Ms. Boso.
Yes, sir.
And where, are those local, or are they back in Mississippi?
They're going to be back in Mississippi.
Is everyone appearing in Mississippi?
I know there's the 2 Mississippi defense attorneys are going to be in person. I will probably be in person. Ms. Bosel's probably going to appear by Zoom, and I may join her by Zoom.
All right, I just want to make sure it's all done.
We'll have it done, Judge.
This is time to go.
Understood.
And just to make sure everyone understands, I don't just look at the date of the case beginning. I look at what I've been told over the past 6 months.
Of course.
And this has kind of been the same thing that's been repeated. I just don't want this docket to continue to be a situation where things can be continued for 2 and 3 and 4 years when we just have a lot of cases to resolve.
Understood, Judge.
All right. So August 27th, well, hold on, August 25th. Where is your client, by the way? Is he?
He's in Mississippi.
Okay.
And
Is he incarcerated in Mississippi?
No.
Okay.
Judge, his family was here on vacation.
Mm-hmm.
And he's also a family member. And they all returned back to Mississippi, and that's when it came out.
I had a very similar case back in practice, but 15 years ago. All right, so I think I understand the situation, but I just want to make sure of what docket we're putting him on. But August 25th at 9 o'clock will be our next pretrial, and by next, I mean last.
Understood.
All right.
What is your jury selection date, if you know it?
Those will be, for that trial period, trial weeks are September 8th and September 15th. I think I may have promised the 15th to someone already. I'll have to go back and look, but those are the 2 weeks.
Very good. Thank you, Judge.
All right, thank you,
for
Mr. Powell.
accommodating me this afternoon.
All right.
Have a good
Have a
day.
good day. All right, Mr. Maddox, I think they said you're lined up.
Yes, Your Honor.
All right, let me see if I can. Yes, ma'am.
Okay, good, man.
Give me just a second, Mr. Maddox.
Sorry, Your Honor?
Give me just a second so I can get to your pages.
Yes, Your Honor. This is Mr. Stephen Arnett, 25 CF 492 to kick things off.
It'd help if I went to the right docket. All right. Go ahead.
Your Honor, I'm asking for continuance in this case. It is his first time up.
Objections from the state?
No objection, Your Honor.
All right. Mr. Arnett, you're going to come back on August 27th for your next pretrial. Is there another case for him?
Not that I'm aware of.
Or a VOP?
Oh, yes, VOP, yes.
Okay, I don't think it's on this docket, but.
No, Your Honor, it's a misdemeanor VOP.
Oh, it's a misdemeanor, okay.
Your Honor, I would like to make a request to the court, please.
Okay.
I was made aware by the victim and victim's family, her father, that this defendant relentlessly keeps calling her from the jail. And there is a no contact order, and the bond was revoked because of the contact that this defendant had with the victim, but he's still not refraining from it. And he uses other phone numbers or other account numbers to get in touch with the victim. So I'm really not sure maybe the court should order that he doesn't have access to phones
Well,
service.
I don't,
If I may, this is the first, I understand there was a concern earlier. This is the first time that specific issue, new contact has been brought to my attention, Your Honor.
is the state seeking new charges?
Based on the phone, I haven't decided yet.
Okay.
I haven't decided, no.
Well, I don't think I can just say, you know what, he's not allowed to use the phone anymore until we have a motion filed as far as to modify his bond conditions. And then I have to figure out if the jail's able to enforce that in some way.
I'll look into it.
But I will
and-
reiterate, Mr. Arnett, no contact means no contact.
Yes, sir.
And each of those phone calls, if they're being made, can be a new charge. Every single one. And if there's a consideration that there's been an attempt to tamper with a witness with these phone calls, that's a felony. So and your bond conditions are always no contact, which means direct contact or indirect contact. So if anyone else reaches out on your behalf, that could be a violation of your bond as well.
And that is happening as well. There is a
Okay,
third party
well,
that I'm just letting the court know.
Certainly,
Again, I'm not an investigative agency. I don't get to look into things. I can only respond to what's been filed.
Yes.
But I appreciate you bringing it to the court's attention. Mr. Arnett, you've been told. If it happens again, I'm sure the state's going to pursue it.
Yes, sir.
All right. Thank you, Mr. Arnett. Oh, and Ms. Basso, I'm still hearing from the court reporter that they cannot hear you. So I don't know if we need to switch seats or just go to the podium on your cases. I think it would just be easier. Go ahead.
Yes, Your Honor. This is Mr. Landon Blair before the court in 25 CF 456. We've reached a resolution in this matter, if I may approach.
Yes, sir. All right, Mr. Blair, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
You're here in 25 CF 456, where you're currently charged with possession of a controlled substance, which is a third-degree felony, punishable up to 5 years in state prison, exposure of sexual organs, a first-degree misdemeanor, and possession of drug paraphernalia. Those are both first-degree misdemeanors, punished by up to 11 months, 29 days in the county jail. And then 2 counts of possession of a prescription drug without prescription. I guess that's a legend drug charge.
Something like that, yes, Your
Yeah, so
Honor.
it's a misdemeanor, second degree. So those are each punishable by 60 days in county jail. Do you understand your current charges?
Yes, sir.
All right, I've been handed a plea and sentencing agreement that calls for you to plead no contest to counts 1 through 3. So that's the possession of controlled substance, exposure of sexual organs, and possession of drug paraphernalia. Adjudication of guilt, 9 months county jail, credit for time served, $615 court costs, $150 cost of defense, and then 90 days to pay those costs once you're released.
Yes, sir.
Is that what you want to do today?
Yes, sir.
Oh, and I failed to mention the state would be dismissing 4 and 5 as part of your agreement.
Yes, sir.
All right. Is that what you want to do today? Mr. Sheik is at the state's offer. Okay, and it's my understanding this is a downward departure.
It is, Your Honor.
All right.
Uncoerced plea.
Okay, so do you understand what that means, Mr. Blair?
Yes, sir, I do.
That the state's offer is what's keeping you from prison?
Yes, sir.
Because they've given you a plea bargain, which you take it without being coerced?
Yes, sir.
Okay. All right. Have you gone over this plea and sentencing agreement with your lawyer?
I have.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, I did.
Are you satisfied with your lawyer's advice and representation in this case?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir, I'm not.
Are you currently suffering from any mental health issues or concerns? Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for this plea?
No, sir.
Do you understand that by entering the plea that there won't be a trial of any kind?
Yes, sir.
You understand that you're giving up your trial rights, which are listed on page 2 of the agreement that you signed?
I do.
Do you understand that you're waiving all potential defenses you may have?
Yes, sir.
And do you understand that if you're not a U.S. citizen, that you could be deported because of this?
I do.
All right. And you understand that one of these charges is a felony for which you'll be convicted, so it's a felony conviction. You're aware of that?
Yes, sir.
All right. Do you have any questions before I accept your plea? And what is
Your Honor, I just want to make sure I wrote it in there. If I didn't, that's clear for the record. It's 9 months total concurrent in the charges.
It doesn't say that, but usually I would assume that, but I'll make sure to say it.
Yes, Your Honor.
All right. Mr. Blair, how do you plead to the possession of controlled substance, exposure of sexual organs, and possession of drug paraphernalia?
No contest.
All right. I'll accept your no contest plea as freely, voluntarily, knowingly given. Adjudicate you guilty on counts 1 through 3. State have an announcement on 4 and 5.
State will null cross those two, Your Honor.
Okay. And sentence you to 9 months county jail on each counts 1 through 3 to run concurrently. Credit for all time served, $615 court costs, $150 cost of defense, and you'll have 90 days upon your release to pay those.
Yes, sir.
All right. So I'm going to need you to be fingerprinted on your way out, Mr. Blair, and you have 30 days to appeal the judgment and sentence of the court.
Yes, sir. Thanks.
As I've previously stated, this is a downward departure based on uncoerced plea bargain, where he scored a minimum of 24 months in state prison before the agreement.
Thank you, Your Honor. Who is this? Bogan? Yes, sir. How do you pronounce it, Bogan or Bogan? Okay.
Yes, sir.
Your Honor, this is Mr. Bogan before the court in 23 CF 1482. Your Honor, I'm asking for a continuance in this case.
Is this the first time up since he got back from the failure to appear?
That's my understanding.
Any issues from the state? Having heard none, August 27th. All right,
Just for clarity, does the state have an alternate case or
Bogan,
You know, just 1 second. I am sorry, Mr. Maddox, what's the question about? I know, I just know. Oh, well, he had an FTA, I see, and that's the reason why it's an older case. I have to let you know, I cannot read. Okay, one second, I got it. It's just hard to see it in the format here, sorry. Okay, the offer that was made was, he scores 8 years DOC, and I made a 3 years offer instead.
Okay. He was thinking, we'll talk about it later. I'll figure it out. Okay, thank you. Right now, the offer's 3 years. I'll talk to him about that.
August 27th for your next court date, Mr. Bogan.
I'll come see you. All right, this is Mr. Brand before the court in 25 CF 848. I'm asking for a continuance. I already spoke to Ms. Berrickman about this. It's first time up. Don't believe she has any objection.
That's correct.
You understand that, Mr. Brand?
Sir?
All right, 8:27 at 9 o'clock. First time up.
Yes. And you know, if you want to write that, the victim, if she wants to change it.
Request in writing.
Mr. Brown?
Trevor Brown?
Yes, Your Honor. Mr. Trevor Brown before the court in 25 CF 758. It's first time up, Your Honor. I would ask for continuance in this case.
Your Honor, the state is transferring this one to the south end.
Okay.
Okay.
That's usually my first question when I see a battery on detainee and I don't see a second case is what was he in jail for when this allegedly happened? So that you may have another case that was somewhere else, but hold on a second.
Did that last time.
Does he have an open case down there? I mean, I'm not prejudging it, but obviously I'd like, want everyone to be on the same page as far as what we're looking at.
Of course. Hey, Mr. Carter.
Mr. Maddox, do you want to set it for Monday, the 30th? Yeah, so you can discuss with
Are you
Mr.
okay with that?
Or is there,
It's a fairly new case. Let's do this, Your Honor. Let's do plea or continuance on the 30th, the 10 months remains open?
It remains open, yes,
Then,
yes.
Yes, plea or continue the 30th. That'll give us some time to.
we're not talking about Keaton or inpatient or something like that?
We
last
had,
time?
Your Honor. I think we're going to run into issues potentially due to the nature of the charges. You know, it's my understanding that it's difficult to get these programs with the nature of the charges, and Ms. Leone and I discussed this case, and honestly, the offer we have, both sides think is appropriate at the moment.
Okay. June 30th, plea or continue. It's the second time up, I believe.
Yes, Your Honor.
Thank you.
Yes, sir.
I thought the door was going to hit him when he bit. Thought it was going to hit him when he bent over and didn't put his hand in.
Steele, Castile.
Sorry about that, Your Honor.
All right.
Your Honor, Mr. Castile's new case, it's his first time up. I would ask for a continuance in both cases.
No objection, Your Honor.
And that, Mr. Castile?
Sir.
See you back on August 27th at 9 p.m., 9 a.m., sorry.
I do have a competency evaluation pending in that case. I think it's internal. Hey, Ms. Creech. Your Honor, I believe the state has an announcement in this case.
Announce the case number, please.
Oh, yes, Your Honor. 24 CF 1619.
EOP?
I'm sorry, I'm not remembering. What did we talk about in this one? Your Honor, I apologize. Would we be able to push this off till a little bit later, just so I can get my ducks in a row and verify?
That's fine.
I thought.
We'll recall you, Ms. Creech.
Talk to him. No, it's going to be dismissed. I need to talk to him about it.
Oh. Do you know when?
It should be today.
Okay.
Bring you back later this afternoon, ma'am. The
Thank you
state
very
just wants to
much.
look at the file again. Did you see this?
Hey, Mr. Crooks.
All right, there.
Your Honor, Mr. Crooks, this Mr. Crooks is before the court in 25 CF 696 and 25 CF 697. I believe it's first time up in both cases, Your Honor. I'd ask for a continuance.
You understand that, Mr. Crooks?
Yeah, I understand.
August
You want
27th,
letters?
9 o'clock.
Thank you.
Mr. Davis.
Your Honor, we've reached a resolution in this case. Just need to get Mr. Davis' signature. It's the 24th. May I approach?
Yes. Just to make sure I understand this.
Yes, Your Honor.
Mr. Davis is here in 24 CF 1400 for a violation of probation with an underline of fleeing to elude law enforcement.
Correct.
24 CF 2059 is a violation of probation where one of the underlying offenses is fleeing to elude law enforcement.
Correct.
His new case is 25 CF 352 where he's charged with, among other things, fleeing to elude law enforcement.
Correct, Your Honor.
And it's a downward departure. You understand what that means, Mr. Davis?
Yes, sir.
It means you score prison, but the state has agreed not to send you to prison.
Yes.
Is there anything the state wants to put on the record? Well, let me go through the plea, and then I'll give you that opportunity, Mr. Sheik. All right, raise your right hand, Mr. Davis. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right. Mr. Davis, you've heard I've announced what, I'll go through it again just to make sure, because the two first cases I talked about, 24 CF 1400 and 24 CF 2059, are both violations of probation. But your new case is 25 CF 352, where you're charged with fleeing or attempting to elude law enforcement, driving while license suspended as a habitual traffic offender. Both of those are third-degree felonies, punishable up to 5 years in state prison. And 3, attaching an improper tag, which is a second-degree misdemeanor and punishable up to 60 days in county jail. Do you understand your current charges? All right. I've been given a plea and sentencing agreement between you and the state where they've agreed to depart downward from your lowest permissible prison sentence for you to plea as charged and get 11 months, 29 days in the Okaloosa County Jail, with adjudications on all counts, all cases, as well as the court costs, which I'll go through. And is that going to revoke and terminate the probation then?
Yes, Your Honor.
I'm showing 58.20 points for a lowest permissible prison sentence of 22.65, absent the agreement. You understand that, Mr. Davis? All right. Mr. Davis, did you go over this plea and sentencing agreement with your lawyer?
Yes.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Are you satisfied with your lawyer's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for the plea?
No, sir.
You understand by entering a plea to the new case, you're giving up your right to a trial and all the trial rights that are listed on page 2 of the agreement you signed?
Yes, sir.
And by admitting your violations of probation in the 24 CF cases, do you understand that you're giving up your right to have an evidentiary hearing where the state would have to prove by a preponderance of the evidence that you violated your probation in the ways they've alleged?
Yes, sir.
And do you understand that you're waiving all potential defenses that you may have to these cases?
Yes, sir.
Do you understand that this will mean you'll have felony convictions in each case?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right, as to the new case, fleeing or attempting to elude, driving while license suspended, felony, and attaching an improper tag, what do you plea?
No contest.
And as to the violations of probation in 24 CF 1400 and 24 CF 2059, are you admitting or denying that you violated your probation?
Mid.
I'm going to accept your no contest plea as freely, voluntarily, knowingly given. I'm going to accept your admissions to your violations of probation as freely, voluntarily, knowingly given. State want to put anything on the record as to the plea offer?
Was part of a uncoerced plea bargain, Your Honor, but the state would like to say that if this happens again, the state will not be seeking the lowest permissible. We will be going much higher than that.
All right, understand, Mr. Davis?
Yes, sir.
Okay. You understand by fleeing law enforcement at high rates of speed through somebody's yard could be dangerous?
Yes, sir.
Do you think you should do that again?
No, sir.
Now that you've admitted to doing it?
No, sir.
In 25 CF 352, I'm going to adjudicate you on all counts, 11 months, 29 days in the Okaloosa County Jail, credit for time served. Court costs as announced by the court, I guess that's going to be $548 in that new case, $150 cost of defense, again, adjudication of guilt. As far as the monetary portions of his probation that's being revoked in term, those will be sent to judgment.
Yes, Your Honor.
24 CF 1400 and 24 CF 2059, 11 months, 29 days with credit for all time served. That'll be a $100 cost of prosecution in each of the VOPs and a $100 public assistance defense fee in each of those cases, also adjudication of guilt. As I said previously, revoke and term the probation and monetary to judgment.
I do believe I put on that those were concurrent. I just want to make sure I catch.
They're concurrent, but I'm not sure how much credit for time served he has in each case, and those may differ between those cases.
Yeah, I've talked to him about that.
All right. Mr. Davis, I need you to be fingerprinted before you leave. You have 30 days to appeal the judgment and sentence of this court. Again, this is a downward departure based on uncoerced plea bargain between the defendant and the state. Thank you, Mr. Davis. Thank you, Ms. Basso. This is Andrew Della Rosa, 24 CF 1700. Mr. Mass, I think y'all were recently appointed, but Mr. Della Rosa had indicated that he was trying to seek new private counsel.
My mother passed away at the beginning of this month. My grandmother is currently trying to secure counsel for me.
Okay. So what would you like to do in the meantime?
Continuance, please.
Okay.
Judge
I guess my concern is you're currently, the public defender's appointed to your case, and they need to work on it since they're appointed. What is the potential timeline on hiring new counsel?
I'm supposed to get an update on that from my grandmother today.
Today?
I'm supposed to get an update from her about it today.
Okay.
Set for 6:30, just see where things stand.
Do you truly think you're going to get an update today?
I talk to her every day, so.
Okay, I just want to make sure. So
We're
what
just
we'll-
waiting on a call back right now.
What we'll do is bring you back on Monday, June 30th, to find out the status of that, because frankly, whoever your lawyer is going to be, they need to get working on your case, because it's just about a year old now. Ms. Basso?
Judge, Mr. De La Rosa did have the PD, then hired Russell Ramey. Russell Ramey then withdrew. PD was reappointed. There are depots set for the 1st of July. They're on our calendar right now. We're not exactly sure which witnesses you needed, sir, but we do have the slot saved for them. So our only concern is, as the court has said, it's getting very old, and it's actually a very straightforward case. If we could set it for
Hold on
6:30
just
for
a
status, that would be good, but it is getting old.
In candor to the court, Your Honor, when were we appointed in this case?
Looks like you were, Mr. Ramey withdrew on 4/30/25. It was granted that date, sir?
Hold on a second. I think I may have figured out the issue. I'm not sure that they were technically appointed.
It did say PD appoint, at least on our notes, sir. I didn't check against the
Okay, I
clerk's
see it over here,
notes.
but Mr. De La Rosa, you have to complete a financial affidavit application for that purpose. That was what was in the clerk's minutes. They don't have either. So, on Monday, June 30th, you're going to tell us if you've got new counsel, or you're going to have filled out an application in the meantime for the public defender, because they don't know if they should be working on your case or not. So you understand, if you stick with the public defender for even the next month and they do depositions in your case and you hire someone else, that new lawyer may not be able to do depositions of those witnesses that have already been deposed.
And Your Honor, if I may, I have travel arrangements to Chicago already booked, made the weekend before the depositions are set.
So who set the July 1st date?
Your Honor, they reached out to us to go ahead and grab a date, which we always ask them to do. We'd rather have something on the calendar than,
I feel there's been no notice and no subpoenas have gone out. So I don't
no, they
think
have
it's-
not. But like I said, that was just set there. We were trying to actually reach back out to the PD and ask them who they were, so that we would know. But we can take it off our calendar,
I
too.
think part of the confusion may be, although it was put in the clerk's minutes that the PD was appointed, in the order that Mr. Ramey said over, that I signed, it didn't specifically address that the PD had been appointed, just that he was able to withdraw.
And I mean, I don't know if the file is at my office or not. I'll certainly make sure to check and see if we do have one open for him. I was not.
We'll readdress it on Monday, June 30th.
Hey, Mr. Frost. Your Honor, could we set this for June 30th for plea or continue? This is Mr. Terrell Frost before the court in 3 cases, 25 CF 884, 18 CF 2999, and 18 CF 3017, Your Honor.
And what date did you want, I'm sorry?
Just June 30th.
Okay.
Plea or continue.
Plea or continue. You understand that, Mr. Frost? We'll bring you back on Monday for a plea or continuance.
Yes, sir.
All right, we'll see you on Monday.
Thank you, sir.
Yes, ma'am.
Appreciate it.
All right.
This is Richard Grady.
Yes, Your Honor. I believe our office announced a conflict in this case, Your Honor, during the pretrial detention that involved a battery on a detainee. I believe my office approved a withdrawal.
I don't believe that case is actually on this docket, sir.
I'm trying to pull it up now.
Just make sure we have the right cases.
Yes, that's the 25 CF 1199. What happened was there a pretrial detention hearing?
There was, Judge,
On the
yes.
19th.
Your Honor.
There it is.
We
Go
had
ahead.
indicated there was a conflict, I was there that day. We had indicated there was a conflict that we would have to get off his cases. You then appointed RCC, and then a discussion was had about being a violent felon of special concern, so you weren't going to have another date for pretrial for pretrial detention, and you were going to.
Well, they weren't seeking pretrial detention, right?
And yes, Your Honor, I did find that email, so my supervisor, Mr. Russell, has indicated that we are going to be withdrawing from Mr. Grady. If the court does not have that paperwork, I will make sure they get it today. That's in all of his cases, 25 CF 1199.
I think the problem is he's got two different case numbers, so be aware of that. And I think for the state too, I'm showing 25 CF 1200 and 25 CF 1199.
Okay.
So I'm assuming those are different cases because they're the same exact charges. There may be a situation where two cases were open for the same issue.
And he also has 25-830.
And then the BOPs as well. So I think the thing is that the 1200 and 1199 case, that for felony plea on July 31st. Mr. Mass, do you expect the public defender will withdraw from all of his cases?
Yes, Your Honor. And I will make sure the court gets that paperwork today.
All right, so Mr. Grady, you're going to be assigned the Regional Office of Conflict Counsel. That should be Mr. Klein's. I think we brought that up last time. So once he gets the paperwork that he's been appointed to it, he'll certainly come out and see you.
Yes, sir.
In the meantime, we'll set all your cases, well, at least the cases that are on this docket, to August 27th, but we still have to get to the plea day. I'm not sure if informations have been filed, so we can't really address that at this point.
Double check the case numbers as well, Judge.
I'm just, in the 1200 case, I don't see that's been assigned a court date, so I'm not sure if the clerk's office is maybe considering that one to be the duplicate one and keeping 1199. I'm looking at 25 CF 1200 is Richard Grady. Yeah, maybe y'all have fixed it on your end and it just hasn't updated in my system yet. I just want to make sure we don't end up with two cases.
We'll take a look at it, Judge.
People are spending time on two different things, like we just did.
Yes,
All
Your
right.
Honor.
We'll see you back on August 27th for those. I think you've got was it July 31st for your plea day for the other cases? All right. Thank you, Mr. Grady. You said green? Green.
That's yours.
All right. What are we doing with Miss Green today?
Your Honor,
That is
I'd
the
ask for
first time up.
continuance in this case, yes.
When do I? Probation.
Leone?
Yeah, it's in my case.
What's the state's offer in this case at the moment?
I'm gonna offer Mr. Sheik to answer that question.
Oh, okay, it's Mr. Sheik's case, my apologies.
May not be, but he's gonna. This is a very, the facts in the underlying case where she was placed on VOP are very concerning. If you want to bring her back on Monday.
Your Honor, could we put her on June 30th for plea or continuance?
Yes, June 30th. We'll bring you back next Monday so they can try to figure out what they want to offer and see if you want to accept it, Ms. Green. That's June 30th, next Monday, 9 a.m. What was she charged? Didn't even see it.
All right, this is Mr. Austin Geis before the court in 24 CF 2576 and 25 CF 375. If we could put him on June 30th for plea or continue.
Anything from the state?
Yes, that's.
Okay. All right.
Yes, yes.
June 20th, plea or continuance.
June 30th, right?
Yes.
I believe the judge said 20th.
I said 20th?
Yeah,
Again, I appreciate it. Some you say the same number 100 times in an hour, you might get it wrong. That's still 99% correct.
Yes, sir.
Thank you for pointing that out.
Thank you, Your Honor.
Yeah, June 30th, next Monday.
Yes, sir.
All right, thank you.
Hey, how's it going?
Your Honor, I'm awaiting a report in this case. It's not a competency report, it's a mitigation report from Dr. Zeman. If I could have a continuance, I'm still waiting that report, Your Honor.
Understand that, Mr. Hartley? Okay. August 27th, any objection from the state?
No objections, Your Honor.
All right, August 27th, 9 o'clock. We'll see you back on that date, Mr. Hartley.
Mr. Moore.
All right, Your Honor, this is Mr. Moore before the court in 24 CF 2894, 24 CF 1358, and 24 CF 1357. Your Honor, we'd like to set 24 CF 2894 for trial. I do need to, it's currently charged right now as an aggravated animal cruelty case and possession of controlled substance together. I believe a bifurcation of the trial would be appropriate in this situation, Your Honor. I'll certainly file a motion on that and get that addressed with the court. But we'd like to set the case for trial.
I don't understand, bifurcation, are you severing?
Severing, yes, Your
Okay.
Honor.
Usually bifurcation is when, like, there's,
Sorry,
no, I just want to make sure that I'm on the same page with you.
Severance of the charges.
All right, well,
State would ask to go forward with the VOPs first before trial, Your Honor.
all right, Mr. Maddox.
Well, Your Honor, I mean, I think a trial is very appropriate in this case. I think that having a jury of your peers decide whether he's guilty of a crime beyond a reasonable doubt is the constitutional right he's entitled to. I believe he should have every opportunity to vindicate himself in that manner before he has to go forward on these VOP hearings, Your Honor. And I think it would be appropriate to have the trial first.
And is the defense there, you're wanting to bifurcate the two charges on the new one? Then the state, if we did that, would be okay with that, but we will go forward on the controlled substance charge first, Your Honor.
If I may, Your Honor, I know that the state historically, in my experience, has been given the opportunity to pick which trial they'd like to go on first. However, I don't believe there's any rule of law, any authority for that actually being required or otherwise adopted. I believe it's just common practice at this court and other court. I believe that the aggravated animal cruelty charge presents the most complex situation, if you will, presents the most issues, has the most doubt involved with it, and therefore it would be defense's position.
I understand, Mr. Max, but you haven't filed a motion to sever.
No, I know, I've got to do that.
So, you know,
Certainly I have to do that, and I'll be prepared to address that on June 30th, Your Honor. But again, our position will be that the aggravated animal cruelty charge is the appropriate case to try, and the appropriate case to try first, assuming that the court grants the motion for severance.
All right, why don't we do this? Why don't we leave it for Monday, file your motion, we can address it on that day.
Yes, Your Honor.
Send a copy directly to my office so I can actually see it before Monday.
Absolutely.
And just, I've recently reviewed 3.152 about severance. I just want to make sure, you know, we've got everything in line. And then, when would you suggest we set the VOP? That would be before the trial dates.
Yes, Your Honor. I don't know when the court's available for. But as long, I mean, we would be ready to go forward on the VOP within a reasonable time to make sure that we can get our subpoenas out.
I understand that. That's,
Yes.
that's kind of where I'm
And that's,
at.
yeah.
Because although there's an extra week before the jury trial week, next week we have docket day. I have civil hearings Tuesday and Wednesday. Thursday is probably still too early.
Yes, Your Honor. If this is the case, we'll just go forward with the trial, Your Honor.
Okay.
And then,
I mean, I'm not trying to be unaccommodating,
Nope.
but then the following week I'm on duty and have civil hearings every day. So I just don't really have a place to put you all before the trial. In fact, that Thursday, July 10th, we've got some arraignments and some other things set that day. But again, I don't think we have the time. We've been putting things on there already.
Yes,
to have
Your
a
Honor.
contested VOP hearing that may involve basically a mini trial for this other case. So, all right. So it's putting on June 30th for trial, and we'll also entertain the motion to sever that day. If you can get that filed and sent over to my office.
Yes, Your Honor, and that was June 30th, correct?
Yes. So I said the 20th again, it's the 30th.
No, I was just talking with my client. I just wanted to make sure
No, it's fine. I just. All right, we'll see you on Monday, Mr. Moore. June 30th. Good afternoon, Ms. Pettit.
Your Honor, we've reached a resolution in this case, if I may approach.
Yes, sir.
But that's okay. You're still go ahead with it. Okay. All right.
How long has she been on probation?
How long has she been on probation, Your Honor? Oh, he might have guessed. How long?
Forgot about leaving.
Okay, let me double check the paperwork. Give me a second, Your Honor. I just want to make sure I get it in the paperwork correctly here.
It's on community control.
Paperwork, but we've got multiple cases.
All right. I found the answer.
Okay.
It looks like March 21st of 2024, she was initially placed on probation for 2 years in 23 CF 1829. The reason I ask is because we're asking for 3 years, or you're agreeing to 3 years of probation, including on that case. I just wanted to make sure that you hadn't been on probation more than 2 years, because if you had, 3 years would be over the maximum. So I'm just trying to make sure we don't set up something that's an illegal sentence.
Thank you, Your Honor.
All right. My understanding is in reading this, is that on the new case, there won't be any probation on that. Is that right?
Correct, Your Honor.
So the only case you guys probation
two
is the
misdemeanors.
VOPs?
Yes.
So are we revoking and terming and doing a new probation with Keaton in the 3 years probation?
Well, I'll defer to the state
Yes,
on that.
that
That's
would
the
be-
easiest way to do it, probably, though.
That would be ideal, I think, Your Honor.
Then yes, that's fine. Do you
Probation
understand that?
have any
Yes.
concerns
Okay.
in that? It looks like she's been on for about 15 months of her 2 years. Okay, I just want to make sure. All right. And it looks like this is a downward departure as well. Correct?
Yes, Your Honor.
All right. And the state's agreement is 3 years probation with Keaton?
Yes, Your Honor.
Okay. All right, Ms. Pettit, now that I think I've got it all figured out, raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
All right, can you state your full name and date of birth, please?
Gloria Dawn Pettit, 122979.
All right, and Ms. Pettit, you're here in 23 CF 1829 with a violation of probation, 24 CF 738 with a violation of probation, and then in 25 CF 343, you're charged with illegal use of personal identification information, which is a third-degree felony, punishable by up to 5 years. Possession of drug paraphernalia and giving false name to law enforcement, also first-degree misdemeanors, punished by up to 1 year in county jail. Do you understand what you're currently charged with?
Yes, sir.
All right. I've been handed a plea and sentencing agreement that would sentence you to, if you admit to the violations of probation, adjudication of guilt, which would mean felony convictions, 3 years of probation, new terms of probation to complete the Keaton program. Do you understand that's not just the inpatient portion, but also the aftercare portion you'd have to successfully complete?
Yes, sir.
Okay. And then in the new case, pleading no contest to counts 2 and 3, those are the misdemeanors, credit for time served with court costs and another adjudication of guilt. Is that your understanding?
Yes, sir.
Is that what you want to do today?
Yes, sir.
Is this a bars to bed?
Yes, Your Honor.
Okay, so that means that you won't be released from the jail until you're going directly to Keaton. You understand that? Okay. All right. Did you go over this plea and sentencing agreement, Ms. Pettit?
Yes, sir, I did.
Did you understand it all?
I did.
It took me a while, that's why I'm asking. And did you sign it?
I did.
All right. And are you satisfied with your lawyer's representation and advice in this case?
Yes, sir.
And are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you suffering from any mental health issues or concerns?
No, sir.
All right. Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
All right. On the new case, do you understand that by entering a plea, there won't be a trial of any kind?
Yes, sir.
And do you understand that you'd be giving up your rights to a trial, which are on page 2 of the agreement you signed? All right. And then in the 2 violations of probation, do you understand by entering an admission to that violation that there won't be a evidentiary hearing where the state would have to prove that you violated your probation?
Yes, sir.
You understand you're giving up that right?
Yes, sir.
All right. Do you understand that you're waiving all potential defenses in each of these cases? And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right. So as to 23 CF 1829, violation of probation, and 24 CF 738, violation of probation, what is your plea? Are you admitting or denying your violation?
Admitting.
Admitting.
And in 25 CF 343, counts 2 and 3, that's the paraphernalia and the giving false name, misdemeanors, what is your plea?
No contest.
All right, and state have an announcement on count 1.
State will no press that one, Your Honor.
You're coming out of the weeds.
Apologize.
All right, so I'll accept your no contest plea in 25 CF 343 to counts 2 and 3 as freely voluntarily knowingly given. I'll accept your admissions to the violation of probation 23 CF 1829 and 24 CF 738 as freely voluntarily knowingly given. In the 2 violations of probation, it's going to be adjudication of guilt, $100 VOP fee in each case, $150 VOP fee, and let's put that in 1829, and $100 PD fee in 738. 3 years probation. You must complete the Keaton program. Again, that's the inpatient portion as well as the aftercare, and that will be bars to bed, which means you won't be transported there until there's a bed available, and you'll remain in the county jail until that point. In 25 CF 343, it's credit for time served on counts 2 and 3. $270 court costs, $270 in court costs. That'll be another $50 PD fee to it. It's a misdemeanor, and adjudication of guilt. All sentences are concurrent. This is a downward departure based on the state's agreement and uncoerced plea bargain. Lowest permissible sentence according to the guidelines was 22.275 months before the downward departure. All right. All right. Let me just say something. I've seen y'all holding your phones up for most of the day that you've been here, so let's turn them off and put them away. So I need you to speak with probation, fingerprint second, and then you have 30 days to appeal the judgment and sentence of the court.
Thank you, Your
All
Honor.
right, thank you. Good luck, Ms. Pettit.
Your Honor, this is Mr. Reeves before the court in 25 CF 152. I'm asking for a continuance, Your Honor. I'll get some depots scheduled.
When are the depots scheduled?
Sorry, Your Honor?
When are the depots scheduled?
No, I said I'm going to schedule the
You're going to
depositions. Yes, sir.
There's no offer. Yes.
Hold on, I'm sorry, Your Honor. What was the state's offer in this case at this time?
I don't think we had an offer at this time.
Okay.
But we'll talk about it. We'll get back to you soon.
Okay.
Thank you.
Y'all want to keep it on for Monday for
Yeah,
that
can we do
purpose?
Monday, plea or continuance, in case something changes with that?
All right. June 30th, plea or continuance.
Monday. Do I come back Monday?
We'll see you back on Monday, Mr. Reeves.
Thank you. All right, this is Mr. Rosario before the court in 25 CF 443. I'm awaiting a competency evaluation at this time. I'd ask for a continuance.
There's no objection, Your Honor.
All right, it's the first time up, August 27th at 9 o'clock.
Your Honor.
See you back on that day, Mr. Rosario.
9 o'clock.
9 o'clock, August 27th.
All right. Good afternoon.
Afternoon.
Your Honor, save the court's time. The state is going to make an announcement. We are going to dismiss the charges based off of the This is Schaffner, correct?
Yes.
Before I speak out of turn.
25 CF 623.
25, yep, CF 623. We will null process both charges or both counts based on the victim's request not to prosecute.
Case dismissed, Mr.
Thank you.
Schaffner. Do you have any other cases pending?
Not that I'm sure of. I'm not quite sure. Yeah, I got my fingers crossed that I don't.
I don't have anything, at least on my docket that I see, Your Honor.
Oh,
Don't you have a case with me?
hold on.
Case with you too?
Yes, but that's not regarding this.
Right.
25
So
CF
he was just trying to figure out if he would
1003.
get released, yeah.
Oh, okay.
We still, you and I still have a case together.
Do you know, will my bond be reinstated?
Yeah, it would.
My bond was revoked due to
Well,
this.
your bond was revoked in the older case because of the newer case, right?
Yes, sir.
Right.
But with that being dropped, will my bond be reinstated to where I can bond
You
out?
have a bond. It looks like, well, let me just make sure I'm looking at the right one. It appears to me that at first appearance, you were given a $2,000 cash or professional on the burglary, just to make sure everyone's aware. It doesn't change what they can pursue as far as a charge. But at first appearance, the judge found no probable cause for the armed burglary, just regular burglary.
Right.
And there was an ROR on the trespassing. So you have a bond in that case, it appears to me.
Yes, he was just trying to clarify with the case that just got dismissed, would he now be able to bond out?
Yes.
Okay.
That's my understanding,
Yes.
unless there's something else. That's,
Yes, sir.
I try to look it up instead of just say, you know,
Yeah, but I appreciate you going above and beyond. Thank you.
I don't know if it's above and beyond. but-
All right. Well, you helped.
All right, so it loost like you've got that case and yours is currently set for August 27th.
Yes, sir. Thank you.
So you want to contact me when you get out, okay?
Yes, ma'am, will do.
Okay.
All right, enjoy your day.
All right, you too. Hold on just a second. Did you bond out on that case at some point, Mr. Schaffner?
I bonded out on the.
No, that's the 623. Never mind.
Yes, sir.
For some reason, there's an affidavit that's filed in this case that's about the other case. All right, I just want to make sure, because I saw an affidavit of arrest and surrender by your bondsman. That kind of threw me off for a second. But, all right. Thank you, Mr. Schaffner. All right, you're welcome.
Okay. Your Honor, this is Mr. Brian Schraufak before the court in 25 CF 440. Your Honor, we did get a competency to proceed evaluation report back. Does the court have a copy? No, it was internal. May I approach with the report?
Sure. State received a copy.
Swore I had 3 in here, but now I only have 2. share my copy, it's fine.
Sorry, Your Honor.
Oh, go ahead.
You're good. So, Your Honor, effectively, I mean, I would posit that this report indicates that he's unrestorable. It also indicates that he potentially has defenses for insanity. Obviously, the report also concludes he's not competent to proceed. I don't know what the state's position is at this time.
The state would ask for another competency eval prior to moving forward with any competency hearing in this case.
I think the first part of the question is going to be pretty easy from what I've read. It's just what do we do next is probably something that they need to focus on.
Yes, Your Honor.
So if, I'm assuming it's going to be Dr. McDonald who will do the
Yes,
second
Your
one.
Honor.
Just also, Mr. Max, just think about what can be done given the situation. It
Yes, Your
sounds
Honor.
like, there are certain needs, but not involuntary hospitalization needs, according to what I just read.
Sure.
I think we just have to have a plan for when we get back with the second report. If it's similar, what do we do? All right. So if you get me that order.
Get you an order, yes, Your Honor.
On the second appointment. All right. And we'll put him on August 27th.
Thank you, Your Honor.
You want this filed under seal?
Yes, Your Honor. Please. All right, they're going to do a second report, okay?
Maybe we'll have to stay longer.
What's the question? No, I don't have it right now. You cannot ask me.
No.
Okay, then don't ask me. Yes, fine.
We do June 30th, plea or continuance, Your Honor.
Who's this?
This is Mr. Michael Strauss before the court, 24 CF 578.
He also has 25 CF 257.
Yes, Your Honor. That's for continuance in that case as well.
All right, you said June 30th?
All both together.
What?
Yes, Your Honor.
So not a continuance, June 30th?
Yes.
Okay. June 30th, 9 a.m. Is that for plea or continue?
Yes, Your Honor, plea or continue.
Mr. Watson.
All right, this is Mr. Robert Watson before the court in 25 CF 274. If we could set this for June 30th for plea or continuance.
30th, plea or continuance, 9 a.m.
Thank you. Mr. Webb. Hey, good.
So much.
All right, this is Mr. Tyler Webb before the court in 25 CF 253. If we could have a July 10th date for this, Your Honor, I talked to the state about this. They need to reach out to the alleged victims in this case.
And what's going to happen on the 10th?
Plea or continue would be ideal, Your Honor.
You just need more time than the 30th?
Correct.
July 10th for status. At 2 o'clock. All right, thank you, Mr. Webb. We'll see you back on July 10th.
Williams, so it's going to be a long before he gets here.
Okay.
I know he needed to speak to Ms. Creech.
I don't think you need to speak to Ms. Creech. I think Mr. Sheik had to take a look at his file about something.
Oh, well, are we ready to bring her back out?
Not just yet. I'd like to talk to the defense attorney first.
Okay.
Problem.
All right, so that's the end of Mr. Maddox. Ms. Rivers, do you mind if I take about a 10-minute recess before we call yours? Give you all a chance to kind of woosah? Sure? All right, there's a juvenile, we'll handle that, and then, Ken, can you turn off for the juvenile?